Yes.
That is also. During item number 15.
Item number 18.
Item number 15. Okay, I have taken the consent of each motion.
Yes.
If this matter can come up after vacation.
All right. You're for the respondent.
I'm for response.
As prayed for on behalf of the respondent and agreed to by the counsel for the appellant, re-notify on give a date after in January sometimes.
Lordship, I also have a similar prayer for item 19.
Similar order on behalf of respondent. You also agree?
Yes, Lordship, that can be fixed on 28th of January.
28th of January. All right.
Right.
Item?
22.
What is this? This is a writ appeal. Is it an old one? This is an old appeal of 2024. As you're for the respondent. No. But just a minute. Who appears for the appellant here?
I'm for appellant, Lordship.
What do you have to say?
It can be on state 28 January.
As jointly prayed for. Can we say as we jointly prayed for? As jointly prayed for, re-notify on so and so. 28th of January.
Right.
All right.
May I please your lordships? I beg to mention item number 15 and 16 lodged.
15 and 16.
Lordship.
What are these? These are all criminal appeals.
Lordship. That will be listed after the vacation lordship. Grateful.
You have started your vacation only now.
Lordship.
3 weeks before the court closes, huh? And that's all right. Those festivities are all right 4 weeks before the Christmas. But then court must go on, no? Huh?
14, 15 and 16 lordship. These are all analogous matters.
All as prayed for on behalf of the appellants in all the 3 appeals. Come on, let these set of appeals come for consideration on sometimes in January. Look at the calendar and then fix the date and tell them the dates.
Lordship.
All right.
Lordship, I'd like to mention item number 13. My senior association.
Item number 13.
Yes, Lordship.
This is again criminal appeal. None of you are interested in arguing criminal appeal before this bench. Why?
Yes, out of state.
Who is your senior? You are ready. Who is your senior?
City Jamir.
Can we help you out? You will have to go through the deposition. We will formulate points for you if that's acceptable.
Lordship, if the matter can come up after 2 weeks.
That it shall. Because if you insist, we will grant you time. But I am only asking if you have the brief, we can help you out. We can argue for you. Nah, you're reluctant. All right. As prayed for on behalf of the appellant, on the ground of unavailability of the learned senior advocate who is to address this court, the matter is adjourned to so and so date. All right.
Lordship, I'd like to mention item number 7.
Yes.
If the matter can come up after 2 weeks.
This is Uplokayukta matter.
Yes, Lordship.
You are not aware of the facts of the case, no? Are you aware? This you can argue. This you can argue. What is your name?
Asaritza.
I'll not be able to pronounce it in one go. But then this you can argue. It's a very small matter. Whether Lokayukt had the jurisdiction to deal with the matter.
The engaged counsel is my senior. So,
Mr. Jamir again.
yes, Lordship. After 2 weeks. It's out of station.
Well, you can't shake your head from behind. You have to come and make an objection. If you object to the time, then you have to come and say, person standing behind you, yes. Acha, you are with him. Yes, what do you say? All right. As prayed for on behalf of the appellant and agreed to by Mr. T.B. Jamir. You are for respondent number 4. As agreed to by the learned counsel appearing for the respondents, let this matter come up for consideration again on so and so date. Sometimes in January. But these are old matters, you know.
Yes, Lord.
Please have it decided, not like this. All.
But if there's an interim in item number 7, interim to conclude, it is an interim.
No, but if there is no order vacating the stay, what happens? The interim order continues. Now, we are not, see, if you ask us to continue with the interim order, it shall be continued by default. But if you ask us to pass an order, we will insist for the matter to be argued today. Do you now ask for it again? All right. Since we are not vacating the stay, it continues. All right.
Yes. 17.
Item number 17.
So that doesn't. It can be listed after winter break.
After the winter break. And you're appearing for the respondent. As prayed for. Any objection? Any objection to
He has difficulties, so.
Mr. Akito? I mean, you are one of the senior advocates of this place, no? Yes. As prayed for on behalf of the respondent and agreed to by the counsel for the appellant, let this matter be re-notified under the same heading on give a date after checking the calendar. All. So we are done with all the appeal matters.
Two left, 2021.
Yes.
Mentioned actually more printed and printed out. And the appeal in the statement case, however, my senior who's leading against the sin.
Do I take it that you people are not interested in arguing before the chief's court? If that be so, then we don't come back again. Tell us. There's no difficulty.
Difficulty, postings came out a bit late last night, so we must face the supplementary list.
Okay. Which item you said?
2021.
At number 20 and 21. How would I know the advocates of this court if you people don't argue before me? If you make a promise that you shall not take time, then I come back again. Otherwise, I would I would be handling the administrative matters from Gauhati and not come back to you again. How would I know all of you? Who is doing what? Who is good at what subject? Unless you argue before me. Anyway, next time that I come, I'll be here tomorrow. Tomorrow I expect the same way because lesser matters would be listed. But next time when I come, I would have cases listed which will be notified and you shall come prepared. And that time I'll not be so indulgent. I'll say prayer refused. All right, then you'll be forced to argue what to do. So this time, all right, you did not. Item number 22, 20 and 21. On the request made by the learned counsel for the appellants. For the appellant, how many appellants on behalf of the appellant? The matter is adjourned to so and so date. आप कितना बचा?
Only orders and admission or view.
So orders, item numbers 1 to 5.
Awaiting the report regarding service of notice on R4. Only respondent number 4 has not been served, no? You are appearing for whom?
Time order for.
You are for the state. Who appears for respondent number 4? Is that the matter?
Still awaited, not that matter.
Who appears for respondent number 4? Has he been served? Any idea? You're Mr. Paul.
Item number two, I didn't.
You're in item number 2. Oh, sure. Otherwise, also this matter would not be.
Will not be taken up.
This will not be taken up because in this composition it shall not be taken up. So we adjourn this matter on the ground that respondent number 4, there is no report regarding service of notice. Okay, awaiting the report regarding service of notice on respondent number 4. These matters are adjourned to. Will yeah. So in this composition, this can't be heard. This is again the procedure to be followed in cases where the tribe, what is that
Customary
called?
code.
Customary codes pass judgments. What is happening today? The appeal goes before the district judge or it comes before the High Court under Article 226.
Now, commission of the district customer and subordinate list. Customer court is under process.
That's
But it's-
again, actually, the rules have to elect, now they are notifying the national ministers of the-
Rules have not been notified.
But they are-
Now, chapter 4 is already.
No.
We're waiting for the. criminal-
All right, I think by the time the court reopens after winter break, I think it should be over. All right, this would have been an interesting thing to add before.
This one.
Now they will be ready.
There should be item number 1, if there's a claim, not should be.
You just heard what we talked about interim.
You are not here.
Huh?
Yes.
Oh, you're not here. If we don't pass an order vacating the stay continues.
For admission,
No
item,
order can be passed. Listen. Now we must make you understand, even otherwise, this composition of bench cannot hear this matter. So we will not be passing any specific order, especially in these 5 matters. So otherwise, if we have not vacated the estate, it continues. All right.
for admission, item number 6.
It will come with others also, 24 and all.
But if matter will be taken up with item 39.
Item number 29, yes.
24 and all this series.
29 all दे दो.
हाँ, तो ये
अच्छा ये सब appeals
सब एक साथ regularity.
posthumous regular. Yes, who leads the argument in all these batch of cases? We have taken up item number 15 first.
State with the file review.
What have you?
State with the file review.
Yeah, all right.
Yes.
All. Yes.
Even call when 2019 call will increase at the office.
There are no other matters. No?
This is there, no? These are admission related display 8, 9, 10.
I don't know. Okay. Okay, we will hear it along with the other matters. I thought all the matters. We can have these matters first.
Just a minute.
Are you all ready? We will start with the matter. PL Badkar. Let's deal with this matter. Yes,
All the items.
all the items. उसी को इतना पता ही नहीं है। Yes. We start with item number 15.
Not 15, we'll start with item number 24.
Okay. Item number 24, yes.
In this case, the petitioner husband, he was a work charge employee and he was on a scale of pay. And he was released on 31/3/2014 after serving for 35 years. He does not come within the purview of the OM 2004, where it prescribed for regularization of work charge employees. And his case is squarely covered by the decision of the apex court.
The decision is something else. That decision is something else. That was the reason why they have filed this petition. Yes.
His case was fully covered by the decision of.
Show us that OM.
Okay.
Show us that OM.
Lordship, you can come to page 67. This is the Supreme Court.
Who is representing the?
Chief.
Membership, listenership.
Please don't ask for any adjournment now.
No,
We have already begun hearing the case.
membership, my senior is attending motion in court too.
That's all right.
So the
Let her-
matter will be taken up some.
Let her argue first. He will come and argue. She's only apprising us of the fact situation.
Lordship, you can come to page 67. This is the Supreme Court action.
No, we are asking you to show that OM.
Okay, the OM. Lordship, come to page 36. This is the OM 2004.
36.
Yes. Lordship, before I take you to this, may I take you to the.
Ms. Shukre, you have to go in the manner in which the court tells you to.
Okay.
Show us the OM and then you show whatever you wish to.
Yes, yes. So
Yes.
Brought into in pursuant to the section 12 of the Netherlands Work Charge Schedule and Regulation Act, Your Lordship.
Yes.
This office memorandum dated
Page?
page 36, Your Lordship.
36, which brief are you having?
Item
Item
24.
24, page 36.
Are we having it?
No, this is item 6. This is the item.
Yes.
This is office memorandum dated 22 September 2004.
Yes.
Policy and scheme for regularization of service of work charge employees.
Hmm.
There are a large number of work charge employees in various departments. Many of these employees have been serving continuously for many years.
Hmm.
They have been representing to the government for regularization of the service. Some departments have been regularizing the service of work charge employees from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of work charge employees. Therefore, in order to examine the issue of regularization of work charge employees in various departments.
Now come to one.
Lordship,
Each department having work charged employees should maintain a list of work charged employees in various categories in order of length of service.
work charge employees will be done against available regular vacancies.
Hmm.
50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees. And the remaining 50% will be filled up as per normal use of recruitment.
So therefore, it has to go by seniority
Yes,
and available regular vacancies.
exactly.
Right.
Then number 4 is work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification.
Hmm.
Such regularization will be considered on the basis of seniority and merit. This means that the senior-most work charge employees.
That's all right.
Yes.
And what has happened in this case?
Lordship, in this case, his seniority at the time of his release, he stands at serial number 19, Your Lordship. Lordship, I may take you to page. Page 64, Lordship.
Just a minute. Give us 1 minute.
Lordship, page 64 is the seniority list. As on February 2014. Of various categories, Lordship. And the petitioner husband is Peter Grade 2. So his serial is at page 66. He stands at serial number 17, Your Lordship. In page 66.
Shows the impugned judgment. Shows the impugned judgment.
Page 74, Lordship, this is the impugned judgment dated 1/5/2023, and the relevant is at page 77, Lordship. Page 77. The last paragraph.
Yes.
77, I may be allowed to read, Lordship. A perusal of the decision of the Honorable Supreme Court in the state of Nagaland and others first, and the Shibi Achumi incident bill number 4223 of 2022, it appears that the husband of the petitioner therein had died in finance while working as portage legally. After a period of 12 years from the deed of the deceased employee. The widow wife of the deceased employee filed a petition claiming that the services of the late husband would have been regularized, and therefore she is entitled to the family pension. It was in the aforesaid factual background of the case that the Honorable Supreme Court had held that the services of the deceased employee was not required to be regularized, as his term had not come and he was much below in the seniority reason. In contrast to the decision of the Honorable Supreme Court that the Shibi Achumi Supra, relied on by the state respondent 1 to 8, it has been.
That's all right. We have seen that. Now you are showing that seniority list. Where is
Yes.
that?
The seniority list is at page 66. He stands at serial number 17, and he was not the senior most.
And any junior to him in Jugali was
No,
it?
Your Lordship, no. And, Lordship, after the death of her husband, only the petitioner filed the writ petition.
That we have followed. That is something different.
Seniority is at page 66, he stands at serial number 17. And none of the persons who are senior to him
Where is
were
his
regularized.
number is that?
At 17, his name is Ikemna Kuyak.
Yes, 65.
Page 66, Lordship. Serial number 17, seniority
And this is the category of?
of fitter grade 2.
How do we know that this is a distinct category?
Start from page 65.
Page 65.
Yes, page 65, there is one underlined line there. Below them, start from 1.
After serial number 22. This is fitter grade 2.
Yes.
Okay, okay.
Yes.
Column fitter grade 2 and then Kohima rural. These are in the districts,
Yes.
different districts.
Yes, yes.
His name comes here at 17 at Mon. This is Ekamakan Konek. Yes. Yes.
Lordship, with regard to the seniority lordship, as per the OEM 2004 memorandum, it says that regulation will be on the basis of seniority combined. Now in their
No, it doesn't say that. It
lordship,
says seniority in the distinct category. They have to maintain that category,
very much.
category wise seniority list.
Lordship.
And then you were there, you see the appellant, the respondent, served for 35 years. He was released from job in the year 2015. He died in 2014. He died in 2015. And then his wife makes an application for posthumous regularization.
Yes.
Now, during his lifetime, he could not have, because he was very junior and there was no vacancy. There is no statement with respect to vacancy position. So therefore, this OM, which is pursuant to the rules of Nagaland, this has to be followed.
Very much.
And the understanding of the learned single judge, therefore, we are doubting that to be correct.
Lordship.
Because he says that the Supreme Court says this, and therefore the person would be entitled. We are really unhappy to say that the widow will not get any family pension, but nothing can be done.
Lordship, one submission can be allowed.
Yes, yes.
Lordship, they still are saying that I'm in serial number 17, Your Lordship. In the seniority list, even serial number 24, Your Lordship, he has been regularized, Lordship. Who is?
That is something different.
Yes, Lordship.
Just a minute. Serial number 24.
Page 66, Lordship.
Yes. Serial number 24. Yes.
24,
Uh,
why when looking at column 10, his date of appointment joining is 27/3/1979.
this is fitter grade 2.
Yes, same post, Lord.
You have two vacancies.
Now, where is that? When was he? During the service tenure of the employee, was he regularized?
No, Lordship. This particular employee was also regularized after their retirement only, Lordship.
Then this will not control, no?
No.
This will not be the controlling provision.
And then it's serial number 11 also. These two particular employees are much more junior than me.
No, that's all right.
Yes.
They may be junior to you, but then,
Article 14, yours.
oh, see, please don't press Article 14 like that so casually.
No, Lordship.
Now, just a minute.
Lordship.
They were regularized after 2014 or before 2014? So therefore, this doesn't apply. This illustration will not apply. And this is what had happened in the judgment of the Supreme Court in state of Nagaland versus Nishibu or whatever. We got a little startled. How can that be possible? We don't have a case. Take down. We have heard M.S. Shukre, learned advocate for the appellant state, and so. Please give your appearance slip. And so for respond number.
For the sole
Full respondent.
For the sole respondent. By the impugned judgment, the appellant state has been directed to regularize the services of the sole respondent as work charged fitter grade 2 posthumously and make payment of pension thereafter to his widow without losing time, preferably within 4 months from the date of receipt of the aforenoted judgment. The state has questioned the aforenoted decision on several grounds, but primarily on the ground of the same being beyond the OM holding the field dated 22/9/2004, dealing with the regularization of work charged employees. The appellant, who is the respondent, who is the widow of the work charged employee, had sought for posthumous regularization of her husband and payment of family pension to her. The husband of the respondent had been appointed as a work charged Jugali (fitter grade 2) as Jugali on 17/3/1979 in the establishment of the executive engineer PHED Mokokchung, Nagaland. After serving for about 35 years, he was released from service on 14/3/2014. He later died on 28/3/2015. It was only thereafter that his widow / respondent made a representation to the state for the posthumous regularization of her late husband on the ground that after her husband was released from service, persons who were junior to him were regularized, and that 35 years of long service of her late husband entitled her to be regularized in service. When her representation before the concerned authority bore no fruit, she had preferred the writ petition the learned single judge, on perusing a judgment of the Supreme Court, in the state of Nagaland and others versus Nishavi Achumi, bracket civil appeal number 4223 of 2022. Found that, what did I say? And a division bench judgment of the Gauhati High Court found that the late husband of the respondent was required to be regularized. The services of the late husband of the respondent was required to be regularized. M.S. Shukre, learned advocate for the appellant state, submits that such conclusion was against the specific provisions in the OM dated 22/9/2004. Page of OM, page
36, Lordship. 36.
the government of Nagaland, in the Department of Personnel and Administrative Reforms, bracket Administrative Reform Branch, has come out with an office memorandum dated 22nd of September 2004, dealing with delineating the policy and scheme for regularization of service of work charged employees. First up, it was necessitated because there were a large number of work charged employees in various departments who had been serving continuously for many years and had been representing to the government for regularization of their services. First up, there was a huge dichotomy in the response of the various departments, leading to different treatment of work charged employees in different departments of the state. First up, in order to streamline the process of regularization, the Department of Personnel and Administrative Reforms formulated the aforenoted office memorandum, which inter alia provides that each department having work charged employees must maintain a list of work charged employees in various categories in order of their length of service, and that the regularization of work charged employees will be done against available regular vacancies. Other procedures also have been enumerated in the aforenoted memorandum, with which would not be necessary for being listed in the facts of the present case. The major contention of the appellant state is that there is no dispute with respect to the fact that the late husband of the respondent was not the senior most in his category of fitter grade 2. Rather, he was at serial number 17 in the seniority list of that category, and that no junior person to him in the aforenoted category was regularized. That apart, there was no vacancy available for regularizing a person who was at serial number 17 in the seniority list till the time such work charged employee continued to serve the establishment. First up. Another argument advanced on behalf of this appellant state is that there has been a skewed understanding of the judgment in state of Nagaland and others versus Nishdevi Achumi. In the aforementioned case, the Supreme Court was beset with a fact situation where a single judge of Kohima bench of Gauhati High Court had directed the appellant state to regularize the services of an employee who had died in harness from one day before his death and to pay to his family, family pension. Stop. The aforementioned judgment of the learned single judge was affirmed by the division bench in appeal preferred by the state of Nagaland. Stop. Thereafter, the matter traveled to Supreme Court, wherein it was held that during the lifetime of the deceased employee, he had never claimed regularization, which was now claimed by her widow after a lapse of 12 years from the death of the deceased employee, and that the deceased employee was not entitled to regularization even on the date of his death, as he was much below in the seniority list and his turn had not come for regularization. His turn had not come for regularization. Considering these aspects of the matter, the Supreme Court set aside the judgment, the division bench judgment of the High Court affirming the judgment rendered by the learned single judge. Learned single judge. Stop. This practically affirms the situation that during the service of a work charged employee, he could be regularized only on vacancy arising in the category in which he is serving, and he would be considered for such regularization depending upon his seniority in that particular category. Stop. It appears that perhaps strengthened by the aforementioned judgment, the respondent approached this court on finding that two persons junior to the late employee had been regularized. However, what was not noticed by the respondent was that such regularization was after the husband of the respondent had retired and had also left the world of living. Stop. That fact therefore would not control the case of the respondent who had not attained sufficient seniority to be accommodated on a regular post, and also that no vacancy was available in that category for accommodating the employee, the late husband of the respondent. Stop. Situated thus, we are in complete disagreement with the opinion rendered by the learned single judge and the direction given by him to the state to regularize the service of the husband of the respondent posthumously and give to the widow / respondent the benefits of family pension. for the aforementioned reasons, we set aside the judgment of the learned single judge and allow this appeal. But the news dead, no? That makes sense. That is not the issue. That can be done. All right. This was in item number
24.
Goodness, very close. Rest foresees absolutely. That's it. Yes, the rest of the matters would follow the suit.
No, my lord. It is. Not certified, my lord. Here, my lord, firstly, it is covered by division bench decision. One, a very recent division bench decision passed by my lord Justice.
Michael,
No. The new judge. Rajesh Majumdar. It was headed, the bench was headed by Kalita. And there's another.
you have to take the names of the judges with some respect.
My lord Justice Kalita.
Ah.
Now, lordships, there's another division bench decision, my lord. Passed by my lord Justice.
That's not the way you rent out the decisions. You have to show to us.
My lord.
What did you understand of the decision? Whether the decision were in the same set of facts.
Yes,
Now let us see the facts individually. If every case has to be decided on its merits, we will hear the cases.
Yes, my lord. Because here.
That's all right. So we'll see. Let the case be called out. Let it.
In
Let it
item
be called.
24.
This is item number
25.
25.
25. Let's see 25.
In item 24, my lord, why it is different is because, like in Nishibi's case, the employee's wife approaches the board, my lord.
No, that is not the controlling position.
My lord.
Anyway, give us 25.
But here in 25, my lord, the
Just a minute. Let's have the.
employee himself.
How would it make a difference? How would it make a difference, Mr. Counsel? What's your name? Mr. Santianger, how would that make a difference? Whether the wife makes.
Nishibi's case, there are two.
No, tell me one thing.
Yes,
Whether any vacancy arose in that category
yes,
where you were serving.
yes, my lord.
You were serving.
My lord.
Category. Have you stated so?
Yes, yes,
All right.
91.
Let's see.
In fact, 91 juniors were recognized. To Kalasi, I was appointed as Kalasi, my lord. I have annexed the RTI information. Whereas in item 24,
In this case, we never get these amounts. The British said,
vacancy नहीं निकला तो नहीं निकला.
this something which was potential create a सबको करते in final procedure of this what is the exam of the case and you
We'll see. Let's see. Let's see. Later. And that also cannot be done. Anyway, let's see. We have passed some order, interim order.
my lord. The same judge who passed the Nishibi decision in Supreme Court MR Shah has passed a decision, lordship, in Kansibai lordship. In another case, my lord. It's a very short order, lordship.
This is very different,
Yes, my lord.
Mr. Santiago. Please try and
Yes,
understand.
my lord.
This just a minute, Mr. There are three kinds of employments. One regular perm, one is ad hoc, the other is temporary, though means the same, but there are different connotations, and these are work charged establishments. Work charge, you understand?
My lord, my lord.
It is charged for a particular work.
My lord.
Now, the name itself suggests that once the charged work is over, suppose work charge employee in the office of executive engineer for the purposes of construction of a canal.
My lord.
Once the canal is constructed, these people lose their job. But considering the fact that they have the skill and they have served the government, they are continued from one work charge to another work charge to another department to the third department. In that case, the first of the cases in 1970s was of Jaswant Singh versus State of Rajasthan, where a distinction was drawn between work charged employee, ad hoc employees, and temporary employees. Ad hoc employees are absolutely ad hoc. They can be terminated with just a notice. Temporary employees, an ad hoc employee would come to a temporary status when he has got some advantages of service. Right. Work charged are absolutely different. There is only one judgment in the country with respect to work charge establishment where the services have been recognized, but that was because of the specific rules of that state. If you're in a position, if you want to know the law and the development of it, you can take down the citation. Not the citation, the case law, which I am going to tell you. This is Mobina Khatun. Mobina Khatun versus State of Bihar, where the state never chose to challenge that judgment. It's a judgment from Patna High Court, authored by Justice Ashutosh Kumar, as he then was. But all the laws with respect to work charge establishment have been taken note of. The full bench judgments and other judgments of the Supreme Court, though it was a long time back, but then it was about 6-7 years back. We had legislated that in the absence of any rules, what is to be done with respect to family pension. The same thing was happening in the state of Bihar. Many work charged employees died and their wives were not getting pension. In some of the cases, because of the court's intervention, they were getting pension. And therefore, this anomaly and whole thing was referred to the full bench. Right, full bench that time, the Chief Justice constituted a full bench of which I was a part, so I delivered that judgment. But I don't say that it was a very good judgment, but it was never challenged. And the facts which we stated in that judgment, the way in which we held that in the absence of the rules, what should be the rules, those were notified as rules by the state of Bihar, and therefore there was no question. So this remains as it is. So I cannot tell you the citation, but it must be of
My lord,
not
I'll try to find it.
Mobina Khatun versus State of Bihar.
I'll try to find it.
All right. So, but here the situation is different. This does not apply.
My lord.
Right.
It may, my lord. It may not, my lord. Now, lordship, there are two division bench decisions, my lord, of this honorable court. Of lordship, same work charge employee, same department lordship, and same length of service, 35 years. And the petitioner himself approached this honorable court. One is reported in 2024, one Nagaland Law Journal 384, lordship. The same additional advocate general appeared in that case as well, lordship. The division bench upheld the single bench decision. An appeal again was preferred before the Honorable Supreme Court, my lord. An advocate on roll was engaged by the state, lordship. The AOR appeared, lordship. And my lord, Supreme Court was pleased to dismiss the appeal preferred by the state government.
But your lordship, the question of law was kept open, so it does not debar us to proceed with the case.
Let's see.
Yes. It's in page 114. I have NH in my appeal memo. 114.
This will not have any binding effect. This judgment does not have any binding effect.
Yes, lordship, but lordship, It may, it may not, Lordship. That, my Lord, I leave it to your wisdom, Lordship. But, Lordship, there is, the point I'm trying to make is there is an earlier division bench decision of this honorable court, my Lord. And, Lordship, in another case, my Lord.
Which has precedence, the Supreme Court or the division bench?
My Lord.
Which has precedence over the judgments, the Supreme Court or the division bench?
Lordship, in this particular scenario, in the particular facts and circumstances, as of today, my Lord, in this particular case.
Look at
Lordship,
this. Every judgment is based upon that OM.
My Lord.
After the OM was promulgated
My Lord.
and there is no deviation from that OM, what we look for is two things.
My Lord.
Your seniority in your category, number one.
My Lord.
And number two, vacancy arising in that category.
My Lord.
And you should be in service. Now I have to put her to a question. There are many cases where my brother informs me that posthumously or post-retirement also you create a situation, you fill up the vacancy with retired work charged employees.
No.
Lordship, yes, yes.
No.
Yes.
Uh,
Paula is here.
uh,
And in fact, it is provided in the office memorandum.
2021?
They retired in 2000.
They must be in service, no?
No, they retired in 2014. They were regularized by creating post in the year 2021 for the purpose of pension.
It is provided in the OM itself.
I am seeking only for purpose of pension.
मुश्किल है उसको बुलाएगा कहाँ? We can't do that, no? We can't. That's
Lordship,
legally unsustainable.
Your Lordship may come to page 87. He is claiming, Lordship.
Page 87.
87, yes. After his retirement, we wrote this letter for page 87. This is a letter dated 23rd July 2020. Administrative approval for upgradation of fixed pay to scale of pay workers employees. I'm directed to refer to your letter dated 5/5/20 and to convey herewith the administrative approval for upgradation of fixed pay level to scale of pay in respect of 31 employees who have completed 3 years or more on 1/7/2020. 1/7/2020. Further, the fixed pay employee who has retired.
Then only it's not
Regularization.
This is a process. So this is the second stage.
So after their retirement, you have upgraded.
Yes,
Then?
we have upgraded, Lordship. After his retirement, your Lordship, we have upgraded.
Then why can't you do it for a person who has died?
Lordship,
Why can't you do it for a person who has died?
Lordship, this is an administrative approval, and they have never challenged this order, and they had already retired, your Lordship. This is only in respect of 31 employees only. Lordship, as on today, there are more than 15,000 WCHARGE employees who have completed 30 years as on 1/7/2020.
No. So in that case,
Yes.
the case,
So this is 11 for
grade 2 है.
after the two, he retired in 2014. So now he's only is the petitioner in earlier case. He is the petitioner. He retired on 2014. He died in 2015. This man also retired in 2014.
Vacancy निकले तब इसके समय मतलब इस समय vacancy नहीं किया.
This is simple.
No, एक बात
ये सब retired.
ये retired हुआ है.
40.
इसको कब रिलीज किया?
21. वही नहीं.
तो 21 में तो था ही नहीं है वो.
नहीं था तो क्या? Dennis. See, आप देखिए, उसमें गति ही लगा तो भाई वो ले argument no, it should be recorded. If you read argument, so specifically what happens before this technique is you have the flow. You don't know. And see, it's and it is it's why they under this is not going to be to scale. After 3 years, really good. This is the this is the baby to do. For that one, something
No, MS Sukre, you'll have to make a statement categorically that after somebody retires and there is no vacancy, you're not picking up. You're not.
No, your Lordship, all person, they are still in service. They are still in service. The petitioner, he retired in 2019. That's why if we read,
No, where the chart shows that somebody had retired in 2014 and you regularized his services, of course.
no. If that is the case, then the respondent show that there is nothing as such, your
The
lordship.
judgment which we have delivered a judgment in that case. Let's see.
The earlier-
Earlier.
कौन सा पैराग्राफ दिखाई? ऐसा हो नहीं सकता है. Page 48. Ex post facto regularization was created with effect the afternoon.
Nine. Yes.
Come to page 48.
48.
Yes.
He approached the court, and on the basis of the court order, he was regularized, your lordship.
No, but you have not challenged this, no?
We have not challenged this.
No, so why do you challenge his?
Lordship, that does not debar us from, we may, your lordship, we may,
Will record. You have to stop this. If you do that, you'll have to do it for everybody.
Page 23. Your lordship, this one is at page 23, your lordship, page 23. The judgment is at page 23.
You are creating a problem for yourself, MS Shukre. The state is creating a problem for itself. That must be stopped. If you give to one, you have to give to others. Take a call.
Your lordship, it's a different.
In that case, we will modify our judgment. We'll say that principally we agree that according to the OM, it can't be done because till the time he served or till the time he was alive, there was no vacancy. But because
Lordship, this was passed before the judgment of this of the Supreme Court. The Supreme Court was passed in 2022, and this judgment was passed in 2018. And the Supreme Court categorically stated that when he does not come within the purview of the OIM 2004, if he is not the senior most, he cannot be regularized.
no, we have passed our judgment.
So
We have dictated the judgment on the basis of
that Supreme Court.
Nishevi and this.
Yes. So the person which you rely on, which we comply is in 2018, your lordship. It's in page 38.
Specific. उसमें एक paragraph only in the earlier judgment. Stop. Mr. Santianger, on the other hand, Mr. Santianger, learned advocate, on the other hand, has not Mr. Santianger.
Mr. Smomatis.
Mr. So-and-so, learned advocate for the respondent, on the other hand, has demonstrated from the records that persons who retired in 2014, that work charged employees who retired in 2014, they were granted the benefit of regularization in the year 2021. He therefore submits that the government cherry picks the employees for regularizing them, which is impermissible. In response to the aforenoted statement made by the learned advocate for the respondent, MS Sukre has drawn the attention of this court to the fact that such regularization was pursuant to the court's orders, court's interventions. But no such regularization is being made post the judgment of the Supreme Court in state of Nagaland versus Nishevi, so-and-so. Full stop. Since the Supreme Court set aside the directions passed by the single judge of Gauhati High Court Kohima bench affirmed by the division bench giving direction to the state to regularize the service and clarified that such regularization has to be within the institution, within the statute, within the framework of the OM dated so and so of 2004, which provides that regularization will be given only on the vacancy arising in the same category, and that each department would be required to maintain the seniority list of each category of work charged employee. Stop. इसमें बीच में insert करना. Yes, this is the reason. Now, if it is post 22, show me. Mr. Santianger, if it is post 2022, please show us.
My lord, then in that case, my lord, lordship, I may be permitted to file an additional affidavit, lordship.
No, tell me, show us from the records. If it is post 2022, we will again put them to question. Otherwise, we are very clear on law. This can't be done. Before that, if somebody has been regularized, we can't snatch it. But otherwise, we can't.
Lordship, I am very certain, lordship, because people I know also.
No, very certain about what? That such regularization
Yes,
has been
yes,
given
my lord.
after retirement, but after 2022.
Yes, my lord.
No.
My lord, I'm very certain, my lord. I know people who have done
That you can't.
Now, my lord, I may kindly be permitted to file an additional affidavit, lordship.
Unnecessarily, this will be delayed.
No, my lord.
If
no.
it's you can come for
Because,
review.
lordship, my
Mr. Imchan, you can file a review petition on factual.
Lordship, I have my RTI, which I've annexed, is 2021 RTI, lordship. So, my lord,
I'm saying 2022.
yes, my lord. Now that information, lordship, I don't have to
File a review petition, but principle remains the same. We can't go beyond law, no.
No, my lord. Lordship,
See, question, just a minute, Mr. Santianger. We understand your, vehemence. This is for the reason that the government is cherry picking. We can't allow that.
Yes, my lord.
But now the specific stand of the state is that this was done by court's intervention, but prior to 2022,
Well,
not after. If you can say that any person was given regularization after retirement when the vacancy arose, that can't be, no. That whatever has been done in the past,
my lord.
Mr. Santianger, whatever has been done in the past is bad in the eyes of law.
Right.
Otherwise, it will take away the service condition of many others. Can't happen.
Now,
It should not happen.
91 of my juniors, Kalasi, I was appointed as Proctor Kalasi. 91 juniors, lordship, have been regularized.
May have been.
Yes.
May have
Now,
been, but
lordship,
post
after-
2022, if you can point out, we give you, we are
Then,
making.
lordship, I may be permitted during the ensuing winter break, lordship, taking advantage of the winter break, lordship, because the court will be on holiday for about 40 days, lordship. So at that point of time, lordship, I may kindly be permitted to file RTI. Yes, my lord. And it can be listed in January, lordship.
I think, Mr. Balgopal, there is a very piquant situation which has emerged. But of course, whatever has emerged, we are very clear on this. Post 2022, there cannot be any regularization without the vacancy arising in that particular category. Previously, courts have been interfering and the state was complying. But we can't do anything about those appointments. But post 2022, we are supposed to follow what the Supreme Court says. Correct. But he wants some time for further affidavit. We will grant him.
My lord. I'll be deeply obliged.
Take इसमें लिखो, next वाले cases में लिखो. Then in all other cases, if,
My lord.
but this law will remain what we have said.
My lord.
Rest others में लिखो, the learned advocates. You are appearing in all.
No, my lord, in items.
Anyway, others do not have any objection if the matter is adjourned. Naturally, you are losing here. Why would you have any objection? It can be dismissed sometimes later. But sir, for you, we have passed on judgment.
I am appearing in items 25, 26, 27.
Anyway, all these, the Mr. Santianger, learned advocate for the
items.
respondents
25, 26
in the
petition.
aforementioned matter submits that he shall be filing an affidavit bringing on record that even after 2022, that is after the delivery of judgment of the Supreme Court in so-and-so, comma, work charged employees have been regularized on vacancy being created even post their release from service after 2000 ऊपर में 2022 दिया है service to stop. If that be so,
It should be post 2018. I mean because he retired in.
post 2022,
No, he retired in.
you have not followed what we have said.
Follow.
You have not followed what we have said. It is post 2022, your decision to regularize
Yes, yes.
with respect to persons who have been released prior to this,
Yes, right, yes.
and the vacancy arising after 2022.
No, it should not be vacancy after because he retired.
Vacancy arising anytime.
Okay.
You cannot do. If you do that, then you'll have to do it for everybody, and you can't possibly do. But for this, you'll have no money left. If they have done it, they'll have to pay through their nose. And in that case, the earlier case which we have decided, that a review petition can be filed.
My lord.
क्या लिखा है? Let those if that be so, the instances be brought to the notice of this court by way of specific governments.
Much obliged.
चलिए, yes, next. Same order in all other matters.
For admission, item number 8.
And MS Shukre, be ready. If he brings any matter after 22 judgment,
Yes,
then we will review that judgment. of course.
exactly. But Lordship, I'm certain that it will not be.
All right.
Yes.
This is what PI.
It is the personal scheme.
What scheme? This is item number.
Item numbers, I think.
All the items. National Food Security Act non-compliance.
Lordship,
Yes.
Lordship, I'm appearing for respondent number 3.
Hmm.
That is the Nodal Department of Social Welfare.
Yes.
This matter pertains to the implementation of the National
Food Security Act.
Supplementary Food Nutrition
Yes.
Program.
Hmm.
Now, this matter was filed in the year 2020 with a limited prayer.
It was filed in which year? 2020.
2020, Lordship. Now, the prayer was very limited that from March 2020 to November 2020, the petitioner is saying that the Anganwadi centers were closed down and rightly pointed out, and we agree to it that the pandemic order had come up and all the Anganwadi centers was closed down. However, the foods were given to the beneficiaries on take-home ration system. So we have filed our affidavits as per the directions of this honorable court in several occasions, Lordship.
No, but what is the current status?
Now, the current position is that after this pandemic was over,
Hmm.
now the ministry has issued a direction that only the beneficiaries who upgrade and upload their Aadhaar card will be given the food items. So that the latest position on 17/6/2025, I was directed by this honorable court to give my latest position.
What is it called? Portion tracker.
Portion tracker, Lordship. So now earlier, if I may be allowed to make a short submission, prior to the pandemic, those beneficiaries who enroll in the Anganwadi centers, the North Department put up in the benefits was given by the ministry. However, there was a clear direction from the ministry that henceforth, only those who upgrade their Aadhaar card and upload in the Pushan tracker, which was formulated by the ministry, only those beneficiaries will get. So for instance, if in a village, one village, although there are 100 beneficiaries, only those beneficiaries who upload and upgrade their Aadhaar card, maybe 20, 30, whichever, only those beneficiaries will get the benefits. That
No, this is with respect to your policy.
Lordship.
But currently, what is the status of the numbers of Anganwadi centers in the state?
So the number.
Have you given the district-wise breakup?
Yes. 3,980 is Anganwadi centers. Total.
And of them, how many have uploaded themselves as beneficiaries?
1,17,558.
Out of how many?
That we cannot ascertain, Lordship.
Because only those persons who upload will be on the grid.
Yes, Lordship, because this is a benefits given to the lactating mothers 0 to 6. So the beneficiaries also keep changing. It phase out.
Yes.
So sometime back in the.
So where is your affidavit?
Lordship, the latest one I was just directed to produce on record. So I'm just produced. As on 31st/5/2025 was 1,25,988. But as I mentioned, all those beneficiaries, the lactating mothers will be again.
Where is that notification which says that they have to upload their Aadhaar and everything? This is a good way of putting everything on grid. Otherwise, these people, these CDPOs, they create everything.
Lordship, my apology, I have not annexed the affidavit outlook, but however, I have mentioned in one.
You have a copy. If you have 2 copies, will be benefited. Because that is the only way in which you can, track and monitor.
Lordship.
Or we can see whether you're doing it.
Lordship.
Have you given a copy to her?
Lordship, I have placed on record, but.
Place everything on record by the next date.
Lordship.
Take them.
Lordship.
Your Appealer Sanctum.
Lordship.
MS Appealer Sanctum Learned Advocate, for respond number 3, submits that the portion tracker is the tool with which the beneficiaries are placed on the grid. According to a government notification, the beneficiaries would be provided with food items to which they are entitled only if they upload their Aadhaar card.
Upgrade and upload the Aadhaar card.
Only when they upload their Aadhaar card. What is upgradation? Only when they upload their Aadhaar cards. Stop. As of now, more than a lakh of such beneficiaries have uploaded their Aadhaar card, and as on date, there is no serious complaint about they being not provided with food items. However, we would like the concerned notification of the government and the updated status regarding the number of such beneficiaries who have uploaded their Aadhaar cards to receive their entitlements be brought on record for us to assess whether the provisions contained in National Food Security Act is being properly implemented. First up, let such an affidavit be filed by the next date with a copy in advance to the council for the petitioner. 4 weeks.
Of
They
late
were-
lordships.
For admission, item numbers 9 and 10.
Sanitary napkins.
May I have your lordships?
Yes.
Lordship, by order dated 3/9/2025.
3/9/2025.
2025.
Let's come to the order. What does it say?
The respondent number 3 has been directed to file an affidavit showing how many adolescent friendly health clinic
3/9/2025.
is functioning.
3/9/2025.
Yes, Lord.
The orders
I think
that
you
was
in the other case.
last of the orders that we have is 19/11.
Lordship,
But
yes.
before-
The affidavit was filed right with that lordship, but since the counsel for the petitioner was not in station, he was out of station, so the matter could not be heard. But the direction was on 3/9/2025, lordship.
3/9.
2025.
I think.
And I filed an affidavit to that effect.
No, this is 11/10/2023. You have a copy of that order? Give the copy of the affidavit. You've already filed, but give your copy. Just.
I've only one copy.
Yes, where is your affidavit?
Lordship, these affidavits filed in the month of October, Lordship.
7th October.
Yes, Lordship.
This file now. You file every date. 7th of December, I find one affidavit.
7th of October 2020.
7th of December. This file.
Correspondent number 1, 2, 3.
1, 2, 3, Lordships.
What have you said? Yeah. 7th of October 2023.
Correspondent for 1.
Yes.
Lordship, may kindly come to Ericshire 5. I've given the
No.
chart, Lordships. The number of adolescent friendly health clinic that is operational within the state of Nagaland, Lordships. page 4. I will be allowed to read Lorships. Adolescent-friendly health clinics, AFHCs, are set up in all districts.
We have
across
only
the state.
12 districts.
There are 37.
Hmm.
As of date, there are 37 that's operational.
These are numbers, no?
Yes.
How many districts Nagaland has?
Lordship,
How many districts we have?
Now it's 17.
now 70 years.
Oh, you have talked about only 12 districts.
So, the others are newly created.
That's all right, but then
We'll be expanding the program. We'll be expanding the programs. But since the board has asked how many are operational, so we are 37 in 12 districts. Lordship. So district-wise, I've break up. I've given the health units where they are adolescent friendly health clinics. For example, Lordship, Dimapur, we have 4.
now what is the evidence of this counseling services being provided in the clinics?
Come to the second page, page 5.
Yes.
So, Lordship, the chart will show that first registration has to be done within the age group of 10 to 19. After registration, then counseling is done, Lordship. So this is a statistic report, Lordship, from April 2024 to March 2024 to April 2025, Lordship.
And have you been providing sanitary napkins at subsidized rates?
Yes, Lordship.
Where are there what is those called sanitary dispensers
Dispensers.
and
No,
destroyers?
Yes, the dispensers are set up by the school education department. They have a scheme, Lordship. So in order not to have conflicting in the program, Lordship, so we tie up with the school education department also. Where they have dispensing machine is there, we don't provide.
Let's accept separately. Any objection that you have?
Lordships, yes, I'm happy that there's some development that is taking place, Lordship. However, the main core issue that is raised in the PILs is, yes, one is related to menstrual hygiene, which was not implemented. Then it was supposed to be implemented throughout the entire state districts. Then, sometime during the pendency of the case, Lordship, the state respondents have filed their affidavit saying that they are implementing it as pilot project, which was initially launched in Kifri. Then they have increased to 2 more districts. So, with regard to PIL 23, Lordship, my prayers are very simple. Let it be implemented, menstrual hygiene scheme be implemented to all the districts, Lordship.
So 12
Because-
12 they have given statistics.
Lordship,
So 5 more districts have been created.
Lordship.
Let's have an updated version and then we decide
Lordship.
then we can close the petition.
Yes, Lordship, and also another petition, Lordship. This is very important here. Why? Because
No, we
the
understand
issue
the importance.
is
We
dealing
understand
with-
the importance of it.
During the at the time of filing this petition, there were only 36 adolescent health-friendly clinics that was operational. Lordship, that is very less for the population.
No, even today it is only 37.
Yes, Lordship, one is going to increase. Now we are talking about the future of our generation, upcoming generation, Lordship. Our youth, adolescents are confronted with so many
right,
issues, Lordship.
Madam Council. That's right, Madam Council. But look at this. Now, out of 14,000, I mean, there 37 such clinics, they are handling a total of 14,162.
Yes. And we have done counseling for 12,000. Lordship, it's a dynamic process, Lordship. Definitely, Lordship, we cannot achieve 100%.
Not dynamic, it's a continuing process.
It is, Lordship. Allow me to apprise this court that as per the population of 2000, census population of 2011, the population of adolescents of Nagaland is 4,78,293, Lordship. That is what the census says, Lordship. Now, our concern here is that
One second before that. Where is the statement with respect to publicity about this?
Lordship,
We can also rope in people from legal services.
yes, Lordship.
Where is the evidence of publicity? Because see, she is talking from the census of adolescents.
Yes, Lord.
Adolescents.
Yes, Lord.
In the state of Nagaland.
Yes, Lord.
This number means that there has not been sufficient dissemination of information.
Lordship.
That you are working under this Kishore, what is this scheme? Kishore.
Rashtriya Kishore
Kishore
Swasthya Karyakram, RKSK in short.
RKSK scheme.
Lordship, for the
No, but we would like to know what is the mode through which you advertise?
Lordship,
Have you gone to schools? Have you told them?
yes, Lordship. The health workers are there, Lordship.
Health workers are where?
in the schools, in the districts, in the health units.
No,
So
no.
they have been educated, Lordship, and they have been
Education is something else. We are now talking about, the target groups,
Yes.
which should have been the beneficiaries, but they don't know about this scheme.
Lord.
So how would this scheme be implemented unless people come and apply for under it?
Exactly.
So for that, necessary publicity has to be made.
Lord.
Now something has to be done about that.
Definitely.
What is the modus by which you publicize?
The IC section is in charge for this.
What is IEC?
The information, education,
Communication.
communication.
Information, education, communication is something
Lordship,
else.
we have taken to the social media also by means of radio transmissions. Lordship, I understand the figure because it's comparing to the population ratio, it's very less, Lordship, but we are giving our best for now to outreach to the
The outreach, you see, the number tells us that the outreach has not been satisfactory.
exactly, Lordship, yes.
What
The
is to
figure-
be
the
done
figure-
about
the
what
figure,
is to
yes.
be done about it?
Lordship, if the
Yeah,
maybe
this
issue
one-
us, Lordship, that we take
Pursuant to the order dated 3/9/2025, passed by a bench of this court, an affidavit has been filed on behalf of response number 1, 2, and 3,
Lord.
indicating the number of adolescent-friendly health clinics set up in all the districts of Nagaland and the number of adolescents who have registered with such clinics. It appears that out of 17 districts in all in the state of Nagaland, such adolescent-friendly health clinics have been established only in 12 of such districts. With respect to 5 other districts, there is no information except that those 5 districts have been created only recently. The The implementation of Rashtriya Kishore Swasth Karikram (RKSK) scheme requires such friendly clinics to be set up in all the districts. The Learned Council for response number 1, 3, and 4, 1, 2, and 3 shall update this court shall inform this court about the number of clinics established in the newly created 5 districts of the state of Nagaland by a separate affidavit. However, what we find from the numbers of adolescents who have enrolled themselves, that perhaps the outreach of the authorities regarding the existence of the RKSK scheme is not significant, as in 12 districts with 37 such clinics, only 14,000 adolescents have registered themselves, out of whom 12,000 and odd have received counseling. The details provided in the affidavit are only with respect to the clinics. set up in different districts. Stop. Since there is a specific stress on menstrual hygiene, this court would like to know whether the outreach regarding information of such a scheme is to various schools where girl students are enrolled, and whether sanitary dispensers have been installed in such schools. The current census of adolescents in the state of Nagaland is
4,78,293.
is approximately 5 lakhs. Stop. It therefore appears that not many persons have been made known about the existence of such scheme and their entitlements. Stop. The Learned Council for response number 1, 2, and 4, however, submits 1, 2, and 3. 1, 2, and 3, however, submits that all efforts have been made and are being made with respect to dissemination of relevant information regarding the scheme, the details of which shall also be brought on record in the fresh affidavit, which would be required to be filed by the next date. Stop. This court would appreciate if a composite affidavit incorporating all the facts stated above are brought on record. Affidavit incorporating all the facts stated above, all the relevant inquiries stated above, be filed by the next date. Re-notify on. I will put it in the last of January. Collate all information and then tell us. Last January.
Lordship, in fact, with just one clarification, Lordship, under Dimapur district, Chumukitima has been separated.
You'll have to.
Yes, Chumukitima is here. And under Kohima district, Cheriju has been.
So whatever, these 5 newly created districts,
yes.
you must have separate ones,
Yes.
no?
So 2 are already in population as the district. Oblige you, Lordship.
Yes.
For admission, item number 11.
Yes.
Lordship, here also I was directed to file an affidavit with regard to the order dated 3/9/2025, correct? Yes. So here also I filed my affidavit with regard to
Blood bank.
blood banks. The query put up before us, Your Lordship, whether the blood bank as well as the blood storage centers are adequate.
Just
to meet
just-
the-
Zui is coming. No, Zui. So you filed that affidavit.
Yes, Lord.
What does it say?
Lordship,
It's
Lordship, may I come to page 6, annexure 9. So
affidavit dated
12th November or 13th
October. It was filed on the same date.
What, because I think to the playground.
Yeah.
Even the feature on a yellow plate. It is in
Hmm.
13th October. 31 first.
Yes, what have you said?
Lordship, Lordship, let me come to page 5, Lordship, page 5 actually. So the medical officer in charge of the blood banks, Lordship,
Page 5.
page 5.
Yes.
Page 6, page 5.
Page 5 is what we put up to the blood bank at Kohima because they manage the whole system, Lordship, from Kohima. Very unfortunately, Lordship, we have only one blood transfusion medicine specialist in Thailand.
Very?
Only one
What?
blood transfusion medicine specialist in the state. And she's posted at Kohima. So all the informations were available in Kohima. So we have written to the officer concerned, Lordship. Now to the query put up by this court, Lordship, she has replied to the queries, Lordship. Lordship, may I come to page 6? Election 9.
20,000 units of blood based on WHO norm of 1% of the population.
With reference to letter number so and so dated so and so. As per the statistics from blood transfusion services of Nagaland, the annual requirement of blood for Nagaland is estimated at 20,000 units of blood based on the WHO norms of 1% of the population. So the chart, Lordship.
Yes. Are you satisfied with this?
Lordship, only one blood transfusion
That's
specialist.
something
Lordship.
different.
That is your Lordship.
See, there has
No.
been no demand for it. There should be as many districts, as many blood transfusion specialists, as many hospitals.
Lordship, yes.
Otherwise, people will go off to other places.
Lordship,
You-
yes.
Where do people from Nagaland go for medical treatment? Guwahati or Calcutta?
Lordship, yes, mostly Gauhati, Shillong, Lordship.
Shillong.
And those who can afford goes to Valor.
Now the state has come up with a scheme, the Chief Minister's Health Insurance Scheme, where they are beneficiaries, government employees, pensioners, as well as the general public. Now, for the general public, it's 5 lakhs. They are given the scheme, the benefit of 5
Right.
lakhs.
The scheme would be available to a person only if he survives. If he needs blood, there is some emergency.
Lordship.
So
Now-
therefore, there should be sufficient blood storage in your
Yes.
state.
Exactly.
And there should be sufficient number of technicians who would help transfuse the blood.
Yes. Now, to that effect, Lordship, I filed an affidavit earlier also, where under the drug rules, a specific requirement of specialists, doctors, to be posted in the blood bank. Now they call it blood center, Lordship. Now, it has been renamed. Nomenclature has been changed from blood bank to blood centers now. There's a specific requirement of qualification for a doctor. Not any just doctor can be appointed, Lordship, under the rules.
No,
Even
that's
for
right.
a technician, specific. Lordship, in my affidavit, early affidavit, I've made a mention, Lordship.
Three blood banks है. The number of
This query was made
transfusion नहीं
on
हो सकता blood bank
13/11/2024.
Total collection of blood unit as per the available records is itna units. Major blood center in Kohima, Dimapur, Mokokchung.
Recently, we have set up new blood centers. I
Where?
filed the affidavit.
You
Four new.
have filed?
Yes, I filed. Lordship.
Where is that?
Lordship, so many affidavits have been filed, so
So therefore, you must update this affidavit, no?
yes.
The three blood centers, now you say another four,
Total, there are no sheets.
7, if your figure is correct.
Yes.
Health department को इसको party बनाएंगे Oh,
Lordship, my affidavit, November 2024.
नहीं
Lordship.
November 24, but this is 25, this is subsequent.
Yes. But the query was before.
No, that's all right. But what is the current number of
Yes, okay.
blood banks,
Uh,
blood centers?
yes.
Mega models, negotiation allowed. Banga have to
The
declare.
total, we have 6 blood bank or blood centers.
As of
And-
now,
Yes, now, yes, and blood storage centers, 6. So those blood centers and blood storage has been put in strategic locations so that in need of bloods, that can
look at this. The PIL has been filed for seeking appropriate directions for setting up of more blood banks, especially in the district hospitals of Peren, Kipire, Longleng. Yes, and
Yes,
consequently,
we have set up. We have already set up.
No.
you already set up. Where is that figure? Where is that detail? Now, show us from the affidavit.
Yes.
We will accept it. If we may not find, you
No, sir,
you say that at present this affidavit is of 13th October 2025. How do you say that within 3 months you have set up blood centers?
No, sir, 4. We have already set up.
No, we are asking for the district, in district hospitals of Peren, Kefire and
Yes.
Longleng.
Yes.
Have you set up or made any effort to set up?
Lordship, during the pendency of the case, it was set up in Kifri. But regarding Longland, Longland is nil, Lordship. Till the time, the affidavit that they're mentioning on the latest update, Lordship. I have also, based on the affidavit, as directed by the court, I have also filed my affidavit, Lordship.
What have you said?
And there I have, based on what they said, I have prepared a chart, Lordship. I've prepared a chart of the blood banks that are available for to assist this court better, Lordship. My affidavit was filed
Yes, the affidavit has to be arranged, no? This
the month of June, Lordship, 2025.
1906.
If you have a spare copy, give it to us. We can't search from this maze of papers.
So the new blood banks are set up in Pingsang, Ifri, Mon, and Phek.
Now, Lordship, if you look at starting from page 3, Lordship, I prepared a chart. Which district has, how many blood banks are there? How many blood centers are there?
Now, Lordship, under the draft rules,
Ten districts do not have any facility of either blood collection center, storage center, or bank.
Lordship, one aspect of that, under the draft rules, to have a blood bank, there should be at least a minimum consumption of 2,000 units in a year. Unless we show that there's a consumption of 2,000 units, license is not granted to us, Lordship. The rules.
The rules say that 1% of the so many units. I mean, it has to match 1% of the total population.
Lordship.
That is the minimum storage in a state. That is what is directed by WHO.
Yes. Now, as per the affidavit, the latest affidavit we have filed, the requirement of the state is 20,000 units. So 20,000 units means 10, minimum 10.
No, it all depends about the location also.
Lordship.
Suppose,
No, Lordship, yes.
so you have to set up a center at each of the I mean, at least in one hospital in a district to start with.
But for that, Lordship, we have to satisfy the authority that we have the qualified person, the doctors.
That also comes under the health department, no?
Lordship.
Lordship, yes.
And we don't have the manpower, Lordship. That is the issue, Lordship. It's not that we don't want to set up. We definitely want to set up. We have to serve the public, Lordship. But the rules, Lordship, the rules.
Take
I
it.
think we have to put in, Lordship.
Pursuant to the order dated 3/9/2025, passed by a bench of this court, an affidavit has been filed on behalf of response number 1 to 4. 124, whatever that is 1, 2, 3, 4.
Yes.
Indicating that up till now, 7 blood storage centers have been set up in different hospitals across 7 out of 17 districts in the state of Nagaland. Though not specifically mentioned in the affidavit, but orally,
No, Lordship, I filed an affidavit.
but orally submitted by Mr. Mazui, learned advocate, representing response number 1 to 4, that the total blood supply in the state of Nagaland matches the requirement of 20,000 units per annum. First up. It has further been submitted that efforts shall be made to have a blood storage center in at least one hospital in each district. First up. However, increasing the blood storage centers in the state of Nagaland is not going to help the healthcare facility unless there are sufficient number of blood transfusion specialists. First up. Unfortunately, in the state of Nagaland, there is only one specialist available in blood transfusion. First up. Mr. Mazui, no?
Yes.
Mr. Mazui, learned advocate, shall inform this court about the efforts made by the health department
Yes.
to increase the number of specialists in the state of Nagaland for the blood in the centers to be used in case of necessity. First, without the presence of sufficient number of blood transfusion specialists and a clear data regarding the consumption of units of blood per annum, no permission would be granted for opening different blood storage centers. This court would like to have a detailed roadmap of the health department regarding increase in the number of specialists in blood transfusion and setting up of at least one blood storage center in one hospital in a district to start with. Let an affidavit in that regard be filed by the next date. Re-notify on so and so date. Up till now, but there has been no complaint with respect to shortage of blood.
Yes, Lordship. That's
something because people do not know that they have got a right. They have got a right to health.
Lordship,
And that under the right to health, they would require continuous supply of blood.
Lordship,
Let's see.
Beyond that aspect, our people tribal society, and everyone come forward to donate blood if there's a requirement, Lordship. Yes. So many times the patient They don't go for the blood, from the blood banks or storage. The family donates.
Everywhere, it's not only typical of tribals, everywhere, the
Right.
close family members, they donate. See, and the centers, if the centers will not give you unless you arrange for donors, because they don't sell blood. They give you for blood.
Yes.
So you must arrange for your relatives to donate blood. Thereafter, you will get the matching blood group.
Lordship, yes.
And that's the
That's the
system.
practice.
Yes.
Oblige, your lordships.
For admission, item number 12.
I remember. Yes.
His Majesty, Judge seeking the appeal judgment by the 11th single judge dismissed my petition on the ground that as the petitioner has participated in the selection process, I was barred by the principles of Aristotle. Therefore, I could not have maintained.
Now, what is the issue? Let's see.
The issue pertains to appointment on the.
Let's see.
basis of
Let's see the judgment first.
Judgment.
That is with respect to landowners.
Yes.
Let's see. Well, just a minute. Well, this will not do. Let's see the judgment. Rishmita का है. Members of Richard Clan have been appointed by the veterinary department. Okay, I don't think it's correct. So again, respondent number 5 has been appointed.
Yes.
Who appears for respondent number 5? Yes, what do you have to say?
Lordship,
This, which judgment have you brought to counter this? That even if you have participated in the
Yes.
interview, you are entitled to point out the follies, because unless you participate, you would not know.
But I have 3 judgments.
There's only one judgment which says so.
On the ground that.
Dr. Madhuri. It's a
Yes,
Supreme
I
Court
have that.
judgment by Justice Surya.
2019.
Yes. Have you brought it?
Yes, I have. Would your lordship like to?
We would like to have a look at it. We are only banking on our memory. If the judgment is before us, we would bring some rescue to you. Mr. Imchen, now you tell us one thing. You are ready?
I'm ready.
All right. Today you are ready. Now tell us, see, respondent number 5 is the nephew of one of the employees, one of the persons who was granted employment.
Yes.
Right? So he cannot have a better chance than the appellant, because one from that family has already been appointed. Now forget about this interview and policy and everything. Now this is not meant for giving employment to only one family or one clan. Everybody has to be represented. Why respondent number 5 was made to steal a march over the appellant, you'll have to give us the reasons.
Your lordship, yes, we are just following the order of the Honorable High Court. Now, in the first read, it was the
Respondent number 5's appointment was cancelled.
cancelled.
Division bench
now-
modified it.
Now
We have asked you a different question, Mr. Imchen. The division bench modified it.
modified.
Division bench said that you pass an order in accordance with law after, putting it to
Advertisement.
advertisement,
So we have done that.
which the policy also says
We have done that.
that you have done. But then you advertise, but then you would filter the candidates also, no? So a person coming from the family which has already got an employment, his uncle was in employment, he retired.
Yes.
Now you have made it a perpetual kind of an employment giving source.
Because the Leonard Division Bench, your lordship of this court, has specifically stated that respondent number 5 must also be called.
So respondent number 5 was called. But his claim, where is the decision of the authority choosing respondent number 5 again?
No, lordship, you'll find the selection process, the mark obtained only 2 qualified. That is respondent number 5.
Page number?
Yes. Lordship, you'll find in 105 of the review.
Page number?
105.
Page 105.
105, page 105.
इसका नाम क्या है? Richa. And number 1 respondent number 5. Marks given by member 1 7.5. He goes to a lowest number. But what is the basis for marking?
Page 103. 103 is the all candidates. But the
Just a minute, scrutinization of original documents are very
103.
indigenous inhabitants, etc. Suitability of the candidate for the post, integrity of the candidate, personality, aptitude, communication skills, full marks for the interview. Oh, so many things. But then you also take into account the policy,
78.
employment or other facility to the landowner and the employment, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner. So he comes from the same family, no? Respond number 5. So only one such person from that family could have been given employment. Where was this into consideration? That is the only ground which perhaps the gentleman can raise. Nothing else. No idea. See, you can't choose one person from one family all the time. Do you dispute the fact that this Richa, the appellant, does not come from the family of the landowner? You can't. So first that has to be certified. And then you can't even deny the fact that respond number 5, the uncle of respond number 5 was earlier given an employment under that quota only. Correct?
Correct.
So therefore there cannot be 2 appointments from one family which has donated land to the exclusion of other landowners. So where has that gone into consideration in the assessment?
no, Lordship, other landowners, because to land was donated by
Order is all right. I'm asking you for, see, you are before a division bench.
Lordship.
With coordinate jurisdiction.
Lordship.
That order may have been modified, but we are now finding it very difficult, especially in view of the policy. Clause 3B of OM number so and so dated 16/8/2018, which is quoted in the first part of the judgment impugned, page 20 of the brief. नहीं brother? I think वो कहाँ consideration में है और डिवीजन बेंच ने गलत किया 5 नंबर उसको भी करवा दिया वो तो he no 3B कहता है 3B है हाँ appointed as landowner in government service does not entitle his no 3B is for landowners only the quota of land.
That they not policy the government to go by.
Read that. It is meant for landholders only, but not in perpetuity. Not that one person, one appointee, if he's retiring, he will ask his son.
After appointment of residents, post the vacancy will be filled up through open advertisement in consonance with existing government policy, giving equal opportunity to all applicants.
That's all.
So it will be an open advertisement. But so the division bench
The
says
question is this, that you have not provided any employment from this landowner's family. So there was that question. The division bench judgment was absolutely wrong.
division. Division.
If I may be permitted let's keep that I for the private.
Why did you not question that division bench judgment modification of the? You should have questioned that.
Look, in that regard,
Let us see the division bench judgment.
yes.
Which page?
Page 76. 71 starting from
71.
operative part is page 76, paragraph 9.
Paragraph 7 is here. Paragraph 7 is
Paragraph?
74. And 7 and paragraph 9.
That's all right, but then where is the proscription in the judgment that you shall not consider this part of the OM dated 16/8/2018 that land donors have to be given? Mr. Imchan, I'm talking to you. You are only supposed to answer. Both of them are claimants. You are to defend this selection.
What of them are claimants? There was only one post, that is why. In the line with the direct.
Show us the advertisement. Show us the advertisement.
Advertisement noted, you will find page 80.
डिवीजन बेंच वो गलत था इसका तो क्लेम लैंड ओनर्स कोटा से है.
This is published in Nagaland Post Daily, which is what we read in the state, all over the state.
There is no mention of quota, which can open and
That cannot.
be.
Open quota, that's all right. Through open advertisement in consonance with the existing government policy giving equal opportunity to all applicants. So this is no quota.
No quota, 3 once it retires, it will go back to the.
But because they are also a landowner and no family member. This whole litigation was with respect to landholders quota.
If your lordship also like to produce.
See, the division is what I'm saying.
No, I followed. They said that
Against that.
this is with respect to perpetuity. Now, just the uncle of respondent number 5 died or retired. In that case, if there were no other you'll have to pitch in here. You'll have to pitch in here. There is some fallacy in the whole policy. And perhaps that was the reason for some misunderstanding when the division bench passed an order modifying the earlier order. Look at this. There are several families which donated land. 4 appointments were made from 4 different families. One of the employees on the landowner's quota, he retired, and he manipulated that his nephew gets into the job. He got into the job. He is respondent number 5 here. Now that appointment was cancelled at the instance of another landowner from whose family no appointments have been made. Correct? So that was this respondent number 5 challenged that judgment after cancellation. The division bench modified the order in a different way, reading 3B of the OM dated 16/8/2018. Now, please show that file to it. 3B is couched in 2 parts. 3B says that it is clarified that it is not the policy of the government to provide employment or other facility to the landowners in perpetuity. So far, so good. The employment or other facility of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendant for further employment or other facility of service on his retirement when he vacates the post. So therefore, don't read any further. Now, this therefore prevents any person from the same family to fill in that void after he retires. Correct? But then every landowner has got a right under an agreement to be appointed if the vacancy comes. If there is no landowner left, then after the appointed landowner retires or vacates, the vacancy will be filled up through open advertisement in consonance. So here a landowner is available. In that case, you can make an advertisement, but why that this advertisement thing comes only later. But because a division bench, I don't know by what reading of the
landowner's right cannot be taken away.
cannot be taken away. Otherwise, you
And I think after 2018, we have banned this, giving employment to, because we had a lot of litigation.
no, if you have banned this,
No, we banned it,
where is that?
as I remember.
So this is
no.
this is prior.
See.
नहीं ये अभी मरने के बाद अभी क्या हुआ?
This will be.
This advertisement was when?
It is just subsequent, but.
तो हो गया बात?
No, this.
No agreement. They'll be sure. Oh, this is what you have to
No,
explain.
it's not banned. I think it's the same notification I'm talking about. That's right.
It is not banned. It is with, now you don't enter into that kind of an agreement. Now, therefore, this open advertisement comes only when there are no landholders available.
When every door is closed, then the benefit should go to somebody.
No, the benefit should be open.
Yeah, the benefit should go to somebody through open method.
By giving employment to respond number 5 again, you have perpetuated this same thing.
And if there is a right available to a landowner,
Already.
then his right will proceed over advertisement, etc. Advertisement is the last resort.
Division bench from क्या चाहिए? Wrong understanding of division bench. ये गलत हो गया.
So please take me to do a final.
Final. See, without realizing.
Somebody else.
Take a call, Mr. Balgopal.
Please, ma'am.
Because we would not permit respond number 5 again to be appointed.
No.
You may not appoint the appellant, but his appointment would be dehors the rules. His uncle had already been appointed. Now that ends. His line ends.
He will be a double beneficiary.
And that will be against these rules. I don't know, that time when the order was being modified, the lawyer should have pointed out that this interview thing has not, this case has not come. There are landholder claimants.
No, Your Lordship, in fact, the division bench did not specifically say that to advertise, but to recruit them strictly based on in terms of the OM. Now the OM 3A, there's a provision where this.
Read paragraph 9 of the judgment at page 76.
Having heard the learned counsel for the parties and after considering the matter in its entirety, you have the considered view that the matter of criminal, the post in grade 4 the veterinary dispensary Jakama shall be strictly in terms of the office memorandum dated 16/8/2018 by the competent authority in the state government. We are not inclined to interfere with the order of cancellation of the appointment of the writ appellant respondent number 5 by the learned single judge in view of the admitted fact that the appointment was otherwise not in conformity with the principles laid down in Article 14 and Article 16 of the Constitution of India by undertaking any selection process in an open and transparent manner. As the
So therefore, when the division bench says that anybody, including respondent number 5, can stake his claim, that means it's an open advertisement.
No.
That's an open advertisement. And in that case, you chose to be there in the advertisement. You
Yes,
chose to
but-
participate only 2 persons.
No, clause 3A. There's a procedure how to recruit and how to verify
Where is that?
the claims.
3A. Where
Page
do
78. Page 78, clause 3A. And I'm saying that this procedure should have been followed.
Where is that procedure? Read.
3A.
Read.
In other cases prior to 26 July 2005 and subsequent to setting up of administrative and block headquarters on freely donated land, where a specific written oral agreement exists providing for employment or other facility to the landowner, the claim of landowner for employment or other facility, the department concerned shall refer the matter to the deputy commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply orders, has been given in the past. Written statements from the witnesses, that is government official.
No, therefore, you're defeating your own claim. Now, this 3A, if you are pressing, you could have challenged the order of the division bench. No. Now, this has been done away with now. Now, what has become operative and what has been kick-started is 3B, later part of 3B.
Yes.
So this goes. And therefore you had to challenge the judgment of the division bench.
No, but then in that case, I'm contending that 3A prescribes a procedure because in our legal
3A prescription will come where then 3B will not be applicable. Here it says 3B will be applicable because all persons.
All claimants as landholders have gone.
So you'll have to seek a review saying that there was a.
Review of the division bench
percentage-
judgment. We'll keep it pending. You file a review.
That is really top secret.
We will indicate that. And we'll say, we'll put it in your mouth. What is your name?
El Iranu.
Huh?
El Iranu.
El Iran.
Iralo.
Yes, Iranu.
Iranu.
Spell it.
IRALU.
Iralu.
Yes.
We'll put it in the mouth of Mr. Iralu that after when the court observed this, he said that he will go for a review. Yeah. That's- Yes.
I was speaking for, sir.
Him to complete. Yes.
So this particular case, even before the learned senior judge, was argued on technical and merit as well. And the appeal, which was just resolved by my learned friend, there the court specifically urged me to participate in the selection process. And this decision was never challenged by the petitioner.
That's what
And that's where it stands, my lord. That's where I'm going to talk. And also, if not in any other case, it's my humble contention that the doctrine of estoppel is clearly to apply in this case for the reason that, my lord, if my lord may.
That's right. You'll have one chance before the division bench.
Yes,
Should he prefer a review?
yes, yes.
Should he prefer a
I
review?
adopt that.
Your
That's my
appointment,
contention.
we are not interfering with your appointment as on date.
Fine.
But this appeal shall remain pending till the time he gets an order, because
Very
we are bench of co-equal strength. The division bench there and this division bench, there is no difference, right? So therefore, unless that order is reviewed, we can't possibly look into it, or he will have to go to Supreme Court.
Very good.
In fact, the better option for him is to go to Supreme Court because that order would hardly be reviewed.
I think after 2018, if I remember rightly, we have stopped this practice.
No, but that's already that
cannot
ban will
bind
not
this
off.
case.
This will not bind.
That will not bind this case because of the fraud.
There was some confusion because the learned division bench, when it opened it for again a
Free for all.
free for all, that was a wrong understanding of PB.
But then the interview board could have assessed whether
The moment interview board comes, you are.
Then
that question will not.
then that 3A is eclipsed. That was the judgment which you should have assailed straight away before a higher forum. But then she's a widow. And he, from his line, somebody has.
And he is in this petition.
Wait a
Serial life for his claim.
Are you interested, or otherwise we'll have no option? Are you interested in filing a review of the division bench judgment? Otherwise, we have no option but to dismiss your appeal.
may I be permitted to take certain instructions and apply my mind again on how to proceed in the case, in all fairness.
Have you followed? We have given you a good avenue.
I'm applying.
Otherwise, the best option is withdraw this petition, challenge that judgment by word. But then it's too late in the day. It's too late in the day. You have lost your case. It happens many a times because of our mistakes, or maybe the council's mistakes. The client suffers. Like here, Mr. Iralu, learned advocate, after some arguments, seeks some time to take further instructions. But let us record our findings. No, let us record our findings. Take note. The appellant hails from the family of 11 different landowners from Jakhma village, Kohima, which had parted with their land for the purposes of establishment of an animal husbandry and veterinary outpost on the basis of a promise doled out to them by the government that from each of the landowners' family, an appointment shall be made as and when vacancy arises in grade 4. First up, the agreement between the landowners and the state was entered into on 8/12/1975. If facts are incorrect, please let me know. Pursuant to the said agreement, 4 persons representing different landowners' families were appointed on grade 4 post, out of whom one Mr. Tepusio Tase retired on 30/9/2021, making one post in that category vacant. Against that category, the nephew of Sri Tepusio Tase, namely, your name, respond number 5 is?
It's at page 3 of the regulation.
One Sivatkul Tase, respond number 5 का नाम लिखना, was appointed, who is the nephew of Tepusio Tase. His appointment was challenged. Bracket में लिखना was your respond number 5 इसको कर. His appointment was challenged by the husband of the appellant by WPC number 77 of 2023 on the ground of such appointment being violative of the office memorandum dated 16/8/2018, which controlled the field then. First up, the writ petition was allowed and the appointment of respondent number 5 herein was set aside. First up, respondent number 5 challenged the aforenoted judgment of the learned single judge before a division bench of this court. Page. Before a division bench of this court, who did not interfere with the order passed by the learned single judge setting aside the appointment of respondent number 5, only modified the order to the extent that a direction was given to the state, keeping in mind the principles laid down in Articles 14 and 16 of the Constitution of India, as also the OM dated so-and-so, that the post be advertised and for consideration, respondent number 5 and others could participate. First up, the government, basing its decision on the aforenoted modified order of the learned single judge, set out to advertise the post in which there were only 2 claimants, namely respondent number 5 and the appellant. First up, the respondent number 5 was assessed by the board to be a better and more suitable candidate for appointment than the appellant, who has stepped in on the death of her husband. The OM dated 16th of August 2088 16.
2018.
I have the OM before me.
16.
16/8/2018. Clauses 3 clauses 3A and B of the OM dated 16/8/2018 is being extracted herein for the sake of completeness as also for clarity. A bare reading of clause 3B makes it very clear that appointment to the family of landowners shall not be perpetuated. It shall be a one-time appointment on that basis, bracket mein landowners quota, and after such appointment and after such an appointee vacates the position, comma, the post would be open for all and sundry eligible persons to apply. However, if under the agreement, if any landowner's family members have not been given employment, comma, though not in specific terms, but okay, what have I said? The last line of the last paragraph, last line that we have said. Comma, the sequitur would be that the first choice would be of an applicant who hails from a family of a landowner from whose family there has been no appointment. There has been no appointments. It appears that while the judgment of the learned single judge was being modified by the division bench, comma, this aspect of the matter went unnoticed, and the order was modified to the extent that the post which had become vacant on the retirement of one of the appointees on landholders quota comma, that was directed to be filled in accordance with the general provisions of providing employment, where every person eligible for the post would be free to apply. In our estimation, the situation had not become ripe for throwing open appointment on such vacant post without exhausting the landowner's quota under the agreement as also under the OM of 16th of August 2018. Mr. Iralu, learned advocate for the appellant, after having heard us dictate the present order, sought the leave of the court to take instructions from his client whether she would be desirous of filing any review petition before the learned division bench, which had modified the single judge's order and which had the effect of throwing open of that post to general public for seeking employment. Stop. Let this matter come up for consideration on so and so day. Dr. Meeta Sai. Sorry, I was remembering Madhuri Sai. Dr. Meeta Sai, yes. It's over. Which matter? Achha, it is 1 o'clock. 2 more matters. We'll come back after this. All right. और पीछे करो. Oh,
For hearing,
so heavy chairs, sir. Yes.
item number 23.
Yes.
Yeah, please go on. Lordship, here his petitioner is convicted.
Appellant.
Yeah, appellant is
That's right.
convicted
That's
under
right. That's
302.
right. We have him.
Under 302, Lordship.
Yes.
Read to be, section 7 and 8 of NSR, Lordship.
Out for a second.
Lordship,
Yes.
he was arrested in the year 2007, Your Lordship.
Hmm.
And since then, Your Lordship, he's in custody, Your Lordship. There was no bail also, Lordship.
He is in custody since 2007.
Yes, Your Lordship.
That makes it how many years?
18 years.
Otherwise, and the sentence is for?
Lordship,
The sentence is for
life imprisonment.
life imprisonment, but with remissions.
Yes, Your Lordship.
So otherwise, he should be released. Otherwise, he should be released. Life imprisonment, a convict with sentence of life is entitled for the remissions. Right? So that makes it to 14 years, unless it is specified that it is for his entire life. It's not there. So I think he should have been released.
That remedy is available.
Not remedy. I mean, he would definitely like his guilt to be, watered down. Let's see what is the judgment.
The judgment is at page 17, Your Lordship.
Yes.
Lordship, here, Lordship. Lordship, only 2 witnesses were examined, Your Lordship.
Give us 2 minutes. You give us 2 minutes if to fit. Yes. How can this be defended? How can this be defended?
Lordships, the deposition of the accused, he has pleaded guilty.
Can a conviction be recorded under section 313? On the basis of a statement made under section 313?
There is no denial at any point of
That's not the way criminal cases are decided. Taylor. We have heard
Sir, Your Lordship.
name.
Esther.
We have heard so-and-so for the appellant and so-and-so for the state. The appellant has been convicted under section 302 of the IPC and section 7 and 8 of NSR Act. What is this NSR Act?
Lordship, this is Nagaland Security Rules, Your Lordship. Nagaland Security Regulation.
Can't be act and regulation both together.
Nagaland Courthouse.
Under section 7 and 8 of the Nagaland Security Regulation 1962. White judgment dated so-and-so. White order dated by a composite order passed on the same day. The appellant has been sentenced to undergo RI for life for the offense under section 302 IPC and to further undergo RI for 5 years for the offenses under sections 7 and 8 of the NSR 1962. Stop. The sentences have been directed to run concurrently. Stop. The period of detention undergone by the appellant has been directed to be set off against the sentence of imprisonment as provided under section 428 of the Code of Criminal Procedure. Stop. 2 persons are said to have been killed. Please take your seats. 2 persons, namely Ajung Chang of Suinsang village and Elimonko Chang of Tubo village, are said to have been killed at the hands of the appellant. First up. Next, on 8/2/2007, ASI Wang Shiliba of Swinsang Police Station, bracket PW1, received a telephonic information by an undisclosed source, by an undisclosed person, that 2 injured persons were lying in a precarious situation near Khiam Church. On such information, he proceeded to the place of occurrence and arranged for shifting of the injured persons to a civil hospital for medical treatment. Stop. It was in that process that the 2 injured persons, bracket deceased, were identified as Ajung Chang and Elemonko Chang. Stop. The FIR was registered. As a complaint was therefore registered by him in the police station, leading to the lodging of Swinsang PS case number 2 of 2007, dated so-and-so, registered for offenses under sections for offenses under sections 302 IPC 25(1)(a) of the Arms Act and Section 7 and 8 of the NSR Regulation 1962, as also Sections 10 and 13 of the Unlawful UAP Act, year लिख देना, UAP Act, UAPA, so and so. During the course of investigation, two persons are said to have heard one of the deceased say that it was the appellant who had killed them. However, unfortunately, none of those two persons have been brought to the witness stand to prove the case. First up, it appears from the records that one Mrs. Tang Chisangla, sister of one of the deceased, namely Elemonko, told the investigator, bracket PW2, that the appellant, a bodyguard of Sipong Chang, self-styled town commander, had come to her place and had inquired about her deceased brother. Later, she learned that her brother was injured and hospitalized. Stop. A cousin sister of Elemanko, namely Mrs. Sungmo Yim, also narrated similar kind of story to PW2, the investigator, that fortuitously she had reached the place of occurrence when her cousin was still not dead, and he disclosed the name of the appellant as the one who had shot him. There was yet another witness during the course of investigation, namely the grandfather of deceased Elemonko, who divulged that the appellant had seduced his minor grandson and his friend, the other deceased. No, he had not seduced. He had persuaded the deceased and his friend, the other deceased, to join his gang after defecting from NSCN bracket IM. On refusal by them, they were killed. This killing was, according to the grandfather of one of the deceased, for the purposes of proving the loyalty of the appellant to his political bosses. Similar such statements were made to the investigator, bracket PW2, but none of them, as noted above, were brought to the witness stand to prove the case. The trial court, after examining two witnesses only, namely the person who received information and became the informant and the investigator, convicted and sentenced the appellant as aforesaid. The PW1 has only confirmed that he had received information from an undisclosed source about two persons having been injured. While shifting them to the hospital, their identities were established. They succumbed to the injuries. There does not appear to have, no post-mortem report appears to have been conducted. There was only inquest report proving that the deceased died of, both the deceased died of bullet injuries. The investigator, bracket PW2, though has narrated the sequence of events and the statements made before him by the witnesses during the period of during the stage of investigation, but those are only hearsay statements which could not be proved because of such persons not having been brought to the witness stand. There was no seizure of firearms from any place. And there was no material on record to justify the conviction and sentence of the appellant under Section 7 and 8 of the Nagaland Security Regulation. So far as the offense of murder is concerned, the judgment, the records reveal a peculiar state of affairs. The trial court has solely relied upon the 313 statement, Section 313 CRPC statement of the appellant to hold him guilty and sentence him under Section 302 of the Indian Penal Code. In his 313 statement, the appellant admitted that he was the bodyguard of Sipong Chang, the self-styled town commander of Swinsang, bracket IM faction, who had been entrusted to recover the two stolen carbines which were found to be missing from the house of Sipong Chang. He suspected the hands of the deceased. He had tried to chase them, but since the deceased persons also retaliated, he had to fire in his self-defense. As also for saving himself from the opprobrium of his political boss, political leader, political/military leader. He further stated that his intention was not to kill them, but to save his life. It appears that the learned trial court, believing such statement to be true, relied solely upon such statement. No. The learned trial, it appears from the records that the learned trial court, solely relying upon such statement, came to the conclusion that it was appellant who had shot at the deceased and killed him. And killed them. There are no eyewitnesses to the occurrence. The reliance of the trial court exclusively on the 313 statement of the appellant is completely a derogation from the established principle of law. All canons of appreciating the evidence, it appears, has been thrown to the winds by the learned trial court. It needs no reiteration that Section 313 CRPC is not, and that the statement under Section 313 CRPC is not an evidence and cannot itself be the foundation for conviction. It can only lend credence to the prosecution evidence already on record. No part of it, including the inculpatory part, could be ever used for conviction of an accused. Paragraph. The prosecution has to prove the case beyond all reasonable doubts. Since a statement made under Section 313 CRPC is not a substantive evidence, it can only be used to corroborate other evidence and could have been relied upon if the prosecution had already proved all the chain of circumstances and the statement under Section 313 would have fitted into and supported the prosecution case and not otherwise. There are various reasons for not holding a conviction on the basis of 313 statement, which is only a supplemental material and not a primary evidence. The purpose of recording a statement under 313 CRPC is to give an opportunity to an accused to explain the incriminating circumstances against him collected during the trial. While making such a statement, he is not on oath, he cannot be cross-examined. And therefore, such a statement has a very low evidentiary value. As has been observed by one of the jurists, Section 313 CRPC is one of the tools to effect fairness in trial, which cannot be made into a source of incriminating evidence. It could, as noted above, only reinforce an existing chain of circumstance, existing chain of proof, but it can never create one. We therefore are absolutely of the view that the judgment and order of conviction and sentence is unsustainable in the eyes of law. That apart, we have found that the appellant has already served out his sentence if remissions are to be taken into account, as he has remained in jail since the date of his arrest in 2007 till date. Thus, we allow this appeal, set aside the judgment and order of conviction, and direct for immediate release of the appellant. Direct release of the immediate release of the appellant. A copy of the judgment be transmitted to the superintendent of jail where the appellant is lodged for compliance as also for record. The records of this case be returned to the trial court, if not required in any other case. ऊपर में लिखना, we have heard swans.
For hearing item numbers 30 and 31.
Yes, Mr. Takamasha.
I had the unique privilege of watching the whole proceedings from 10:30 in the morning till now.
Okay.
Was a fun match.
What is this matter about?
Lordship, the issue is the petitioner, the matter relates to one of whether the contention of the writ petitioner. Respondent is the rule of the game was changed.
No, but you are appearing for the respondent.
I
No.
am for the respondent.
So let's see what the appellant has to say.
I'm the appellant.
You are the appellant
I'm
here.
the appellant because my
How come is he?
my appointment was terminated.
You've changed sides. No, doesn't matter. This is the acceptable position.
Yes.
This is the most acceptable position. But in Nagaland, I see people, appellant stands there and the respondent stands there.
Comments yesterday and
Wonderful. This was not to stoke or change your traditions, but then I think it's practiced everywhere. Ask Mr. Balgopal, Supreme Court, everywhere, it is the same thing.
Here, Lordship, since the state government occupied this area from the very beginning, from the inauguration of.
Now, this is no encroachment or occupation.
Yes.
It can always be changed. They can switch over to that side.
I hope you will not claim for a first position afterwards.
Nobody is going to question then whom are you appearing for?
Yes, Lordship.
Yes.
Lordship. Now, my Lord, before I go to the impugned judge, may I be permitted to keep the facts in 3 minutes?
Yes.
Lordship, an advertisement was issued in the year. An advertisement was issued on 21/11/2015 for filling up a vacancy of secretariat assistant in the governor's secretariat. And the condition is that it is confined to only 5 tribes. There's only the 6 tribes of Eastern Nagaland. Chang, Kembangan, Konya,
Where is the advertisement? Simultaneously, if you take us to the records, we'll be happier.
My lord, 124. My lord, not to kindly allow me, I'll show you the. Yes, 124 says it is.
Yes.
Now, applications are invited in plain paper giving for.
Page 124.
Not, yes.
This is the ITI information. Information sought a copy of the calling.
It is 124.
You're in writ appeal number 22 or writ appeal number 9?
9.
Oh.
I'm sorry, read the number 9. I don't know.
Yes. Yes. Page 124.
Yes.
There are many judgments kept here.
Yes, my lord.
Was this matter argued ever before?
My lord, I place the judgments in the conversation.
Shivanand and all. Yes, 124.
Yes. So, my lord, for 6 tribes, then, my lord.
Just a minute. Applications invited and obtained purpose. Belong to Chang, Kimyong, Konyak, Phom, Sanctum, and so many tribes of Nagaland. Fill up the post of secretary.
Kindly take note of that. It is only from serving candidates. Her second line on the top.
From serving candidates.
Only serving candidates. Only
yes.
employees can apply. Not fresh. Then, my lord, the eligibility criteria is given from the terms, lordship, graduate, is the eligibility criteria, and lordship. The issue arises from the examination, the methodology of 125. The next page. Initially, lordship, 100 marks written, then for that is 50 marks, then the criteria 50 marks for to be considered for written, 30 marks oral, 20 for work experience, that is special knowledge in of test reasoning, simple arithmetic science. So, lordship, you can take note of that. It is 50, 30, 20. Then, lordship, when the calling letter was issued, next page, page 126, the type copy is 127. My lord.
Just a minute. Yes.
When the calling letter was issued on 8 February 2016, lordship.
Yes.
It was lordship, you can see serial number 3. In partial notification of the secretariat condition, secretary's commission replacement, the written examination shall be for total marks of 200 marks, 150 marks of multiple choice, and 50 marks for active subjective type. Then lordship, you can come to 6 and 7. The top 15 candidates will be shortlisted for oral interview, provided we have obtained a minimum of 50 marks. 50%. 7 lordship. This is the flash point of condition. The final selection of the candidate of those calls for interview will be done as under 60 marks for weightage for written, 30 marks for oral interview, and for professional qualification, 10%. So, my lord, from 50, 30, 20, it is now changed to 60, 30, 10. In the, my lord, in the calling letter. Thereafter, lordship, your lordship, you kindly see at page 131. The written examination was conducted on 13th of July 2016.
131.
131.
Yes. Written examination conducted on 17th of June 2016.
13. My lord, it's a letter dated 17th June. Lordship, may kindly say it's still number 2.
13 July.
13th July. Thereafter, lordship, on 12th of July.
A day before.
A day before. The board had a meeting. And lordship, the minutes of the board meeting, lordship, 159.
159.
Lordship. This is the bone of contention, lordship. A selection board meeting was held on 12th at the office chamber of the Commissioner Secretary to shortlist the candidates for oral interview based on the marks obtained in the written examination with the following members. Then such and such. On the scrutiny of the work experience, knowledge, and proficiency in computer, educational, and professional qualification of the candidates shortlisted for written tests, the board, after taking into account the work's experience and special qualification possessed by the candidates, has observed that there's a need to review the marks kept for oral interview, and after detailed discussion, it was decided that marks in the oral interview be reduced from 30 to 25, and the marks for the work experience, knowledge, proficiency in computer education and professional be increased from 10 to 15. The total marks will be 40 as given in the call letter of the candidates. The final selection of the candidates of those for interview will be as under. Total marks obtained in the written of 200 marks will carry a weightage of 60%. Oral interview shall carry a weightage of 25. The overall assessment.
So this was, you say that this was change of game midway.
That is the contention of the writ petitioner. I'm the respondent, I was appointed. So my lord, here, for the work experience, it was increased from 10 to 15.
That's we have followed. We have followed.
Yes. So my lord, next page, 160. This is, then Lordship may kindly allow me to read the last paragraph at 159. It
was to put notice board.
Notice board. And marks, my lord, the notice board was at the place where the exam was, written exam was conducted. And on that day, how much marks were secured out of 15 by all the candidates were displayed. It is not, there was total transparency because before the, for the written interview, he knew how much he scored out of 15 in the work experience.
That's right.
Then Lordship may kindly say 160, a serial number 28. This is the respondent number 6 applicant. I scored 12 out of 15.
You are number
28. Serial number 28.
You got 12 marks.
Yes. Then my lord, serial number 36, next page. The writ petitioner respondent obtained 5 out of 15.
This is item number 36.
Yes, Lord. That is the writ petitioner respondent.
That we have followed.
Now, my lord, next 162, page 162. My lord, the minimum to be qualified from written examination was reduced from 50% to 45% on 13. But, my lord, both the parties, the two contending parties, had scored more than 50%. So, my lord, though it is reduced from 50% to 45%, my lord, do not have a bearing. We could of us have scored more than 50% in terms of the aid to calling letters. Then, lordship. So, my lord, then lordship, we kindly see the mark sheets of the candidates. My lord, at page 141.
Now, this is the process which is under question.
Lordship,
So
yes.
therefore, mark sheet would not be important.
Yes.
Now, let's see what the single judge has said.
Yes, lordship. Lordship, lordship, may kindly allow me the operating paragraphs starting from lordship page, my lord, 85. Page 85, paragraph 37 and words.
Page 85.
Lordship, paragraph 37 and words. My lord, yes, till the end. Because, my lord, the issue is, my argument will be on two legs. Process is fair and transparent. And secondly, the benefit of equity. Because lordship is well aware, and in Dash Prakash, the other day, lordship, he was pointing out about paragraph 65.4. I did not read that recruiting body subject to the extent.
But then while I pointed it out, we also said that by this judgment, Manjushri has been affirmed.
Yes. And but lordship, in paragraph 34 of that judgment, court has made a distinction. In Manjushri, what has happened is the examination court were not aware of the changes. They were under the presumption that rule is not changed. because rule was changed after the Viva was over. Minimum was set, and qualifying mark was set after the Viva was. Here, Lordship, the examination board, because board had a meeting on 12th July, and he changed it, it was notified. So on the 13th, when the examination was held, oral interview was held, the board members were all aware that it is 15, that it is changed. So where's the question of in favoring or favoritism? Because
No, that's all right. Let's see what the judge has to say.
Lordship, yes. From paragraph 37, Lordship. But he refused, the Honorable Single Bench has said that the game of the, by the second notification on 12th, my lord, the first observation of the Single Judge was when the mid court was issued on 8/2/24/25, and changes were made, the petitioner parties were not taken, there was no element of surprise.
Good.
But the finding of the Single Judge is that when it was retired and when it was published in the notice board on 12th, prior to the written examination on 13th, since it was only displayed in the notice board, some people may have seen, some people may have not seen. So there's a so in that view of the method, that was in violation of the 14/60. That there is an element of surprise, sir, because it is the condition of the petitioner that he came to know about the changes after.
Please read that paragraph.
We are from 37 and on.
Yes.
Reverting back to the facts of the case in hand, it is found that the criteria of selection originally outlined in the advertisement dated 2015 were changed after scrutiny of the application received in response to the advertisement dated 2011-25. And before the point of issues of calling letters on 8/2/26 to the candidates shortlisted after scrutiny of the application received. Though by the call letter dated 8/2/16, the written examination was in research on 16/3/2016, with the oral interview tentative schedule on 17/3/2016, the written examination to the postponement was finally held on 13/7/2017. For the written examination scheduled on 13/7/2016, call letters were issued on 17/6/2016, stating the terms and conditions and instruction guidelines issued by the Secretariat by the advertisement dated 21/11/2018, and the call letter dated 8/2/2016 remained the same. That it not be said that 56 candidates who sat in the written examination on 13/7/2016 were not aware of the criteria of selection notified on 8/2/2016. Thus, the element of surprise was missing at that stage. Since these 56 candidates, including the petitioners, appeared in the written examination on 13/7/2016 without any timor, it is open for these candidates to say they were caught unaware of the change selection criteria and were surprised. It is worthwhile to mention that the criteria of eligibility were not changed. Having recorded observations in paragraph 30 in paragraph, this court finds the change in the selection criteria well in advance of the written examination in the aforesaid stated manner did not cause any prejudice to the participating candidates to allege violation in touchstones of Articles 14 and 16. My lord, 1338 is consciously taking part, and so my lord.
Just.
Yes.
Unnecessary judgments of court. Yeah.
Don't you kindly allow me to stress much on paragraph 39, the last 7 lines from the bottom, itself.
Paragraph 39.
Paragraph 39, the last 7 lines.
Hmm.
Though it is averred, last 7 lines on the bottom. Though it is averred in the application of the official respondents of the marks of the work Mark's work experience was awarded to the candidates before the overall review and same was displayed in the notice board. It is noticeably not apparent that the changes in the selection criteria pursuant to the decision of selection on 17/12 to 17 about lowering the marks for overall segment from 30 to 25 and enhancing the marks for the segment work experience, knowledge, and proficiency in computer educational professional qualification from 10 to 15 was displayed in the notice board. It is categorically stated by petitioners in the pleadings that petitioner had appeared in the selection process without knowing that the selection boards in its meeting held on 17/7/2016 and 13/7 had completely changed the terms of the condition. So that is a contention.
Yeah, power fair.
Lordship, yes, Lordship, my submission will be, since it's only a question of law. First submission, Lordship, that the learned single judge has failed to appreciate. First submission, my lord, the rule of the game was set at 3 stages. One, when the advertisement was issued, no complaint. When the calling letter was issued, Lordship,
He himself, the judge himself says that there is no difficulty.
there is no difficulty with the calling letter. Now he is only saying he has got no difficulty in the calling letters, but when it is issued in the notice board, he is having difficulties. 1 day before it, notified most transparently, it is Raj Bhavan Lordship, not other some associate organization. It is Governor Secretariat so fairly, and how much was scored out of 15? Everyone was notified. So the day you appeared at written exam, you know how much you scored in your work experience. So that is one aspect. So my respectful submission is that, Lordship, the learned single judge has failed to appreciate the principle laid down in paragraph 65.4 of Dej Prakash, that a discretion has to be given to worked out. Because, Lordship, the object of a selection process is to, in a public service, is to appoint the most suitable person. So in that situation, a degree of discretion is necessary to be left with the employer to decide its method, procedure to select the candidate most suitable for the job. So that is what is done here. And Lordship, I kindly appreciate the fact it is not fresh employees, all regular employees. I was serving as senior inspector in the Department of Corporation. I have to resign my job after being offered. While the respondent rate petitioner is presently serving as a lower division assessor in the transport department, she's continuing his service. For me, my lord, this is my admit card. My date of birth is 15/1/1984. So more than 40 plus years of age. Where shall I go now? Now, my lord. So my first submission is that the learned single judge has failed to appreciate paragraph 65.4. Secondly, Lordship is well aware of the Sivanandan CD judgments in paragraph 55 and 56 and 57.6. Paragraph 57 starts with a bold headline, great. What relief should be given? What shall the court do? Lordship, I have placed the judgment. Lordship, you can see. The first one is the
Shivanandan CT.
Sivanandan CD. Lordship, you can see the paragraph 55, paragraph 55. One on legitimate expectation, Honorable Supreme Court held that the appellant have no merit. Thereafter, Lordship, can you read from 54? The High Court decision also fails to satisfy the test of consistency and predictability as it contravenes the established practice. The High Court did not impose a requirement of minimum kata for the Viva voice for the selection to the post of district selection judges for 2013 and 2014. Although the High Court's justification, when analyzed in its own terms, is compelling, it is not ground on legality. The High Court decision to apply minimum kata for the Viva voice persuaded of substantive legitimate expectations. Since the decision of the was legally untenable and those are the touchstones of fairness and consistency, predictably, we have hold that such a course of action is arbitrary and violative of the Article 40. What this court should do, the question that which now arises before this court is carted relief, which can be granted to the petition. The final is that the successful candidates were issued on 6/3/2017. The candidates who have been selected have been working in district and session judges for about 6 years. In the meantime, all the petitioners who were before the court has not functioned as judicial office. At this lapse of time, it will be difficult to direct either the unseating of the candidates who have performed their duties. Unseating them at this stage would be contrary to public interest since they have gained experience as judicial officers in the state of Kerala. Well, the presence of the petitioner is that if the grid of marks in the written examination in Viva voice were taken into account, we would rate higher than the 3 candidates who are respondents to this proceeding. Actually, we cannot lose sight of the fact that all the candidates are otherwise qualified for judicial office and have been working over a length of time. Unseating them would, despite being harsh, result in a situation where the higher judiciary will lose the service of qualified officers who have experience over this 6 years of service. Then, Lordship, my lord, thereafter, Lordship, the conclusions. 57.6, my lord. 57.6, Lordship. Although this judging was deferred by the same 5 judges who have delivered a reference in Dej Prakash. No, Lordship.
Just a minute.
Yes, please. I'm sorry.
No, Lordship.
1 second, 1 second, sir.
Please. I'm-
1 second.
I'm sorry.
देखो एडवर्टीजमेंट है एडवर्टीजमेंट है 21/11/2015 ठीक है हमको डेट याद ही नहीं रहता है ठीक है ना ये कॉल लेटर है कॉल लेटर कब का है 8th of February 2016 16 ये तो ठीक हो गया परीक्षा कब हुआ है एग्जामिनेशन हुआ है 13/7/2016 ठीक है उसके बाद बोर्ड की मीटिंग हुई है
12/7.
बोर्ड मीटिंग on 12/7/2016 इसको इंटरव्यू बोर्ड पर कहा है
Interview start on 14, Lordship.
then the result that's right and the result comes marks obtained work knowledge 160 is the marks and then she was respondent number 6 she was appointed appointment letter coming page 191 again लिखा था सीधा फेस प्रताप पर आइए फेस प्रताप
Lordship, the judgment in this and C.D. Sivanandan was followed. Lordship in the.
No, that's right. We are going by Tej Pratap and Shivananda,
Follow-
legitimate
The
expectation.
point here is this, the one point I find of like here, in issue was raised here by the division bench of the Supreme Court in why not I'm very not familiar with the name Vivek Ice. Here, Lordship, the Himachal High Court, Honorable Himachal High Court rejected the petition by the division bench on two grounds. That equity only under 142, Honorable Supreme Court have the power to do complete justice. And equity, if any to be given, it should be in the favor of the petitioner, not the respondent. On that ground, it was rejected. On appeal, Lordship, the Honorable Supreme Court in paragraph 39 says that the learned division High Court, we have already clarified the position of no, therefore in our opinion, the High Court was right in holding this position, which is a settled position of law. What the High Court is was the context, the facts, and circumstances of the case, that the fact that we were serving for 10 years, running 10 years. In paragraph 42, the appellants were not entitled for equity relief in view of the High Court, as they were the beneficiaries of an illegality committed by the selection appointed.
No, we are not, Mr.
But
Takabashi.
then,
Our focus is not there.
but then, Lordship, I'm coming to one point. This, but then it failed to take this question further. Because Lordship, I was appreciating the fact that Lordship was stretching the issue yesterday to examine from multiple angles. So here, the Honorable Supreme Court has stressed the issue and bring it a third point. In that is, that. But then if the High Court, then it feels to take this question further, which in our opinion it ought to have done. What the High Court never answered was to how much of this claim of illegal selection and appointment would rest on the High Court and the administrative side.
Would? Okay, what did
Would
you?
rest, but what the High Court never answered was how much of this claim of illegal selection and appointment would rest on the High Court and the administrative side. In other words, my lord, here I am in a particular situation. I was holding a comfortable job in a regular place as senior.
You've said.
Then thereafter I am 42 years. And
No, we have
a
followed.
request was given, and for no fault of me, now if I'm chucked out from service,
No, no.
I cannot go back.
Yes, let's hear him first. Yes.
That is the law.
Another case is by state. State is agreed by. Why?
Police were essentially completed.
All right.
So that is the issue of it.
All right, please. Yes, you have been very brief and very focused. We are happy.
Much of like.
We are very happy. Yes.
Well, very pleased, Lord. My lord, the only law involved here is one is, Lordship has clarified as per the yes, Prakash case, paragraph
65(4).
65(1). Recruitment process commences from the issuance of the advertisement.
No, that's right. So, Mr. Counsel, that's a very big argument from your side that it starts. But then K. Manjushree talks of various benchmarks at various stages, which has been affirmed in this judgment. So this also says that at various stages, different benchmarks could be set. But then there has to be knowledge. It must be rational. It must not be bad.
Now, in this case, what happened? Advertisement was issued on 21/11/2025 to 2015. Only for those who are in service, both of us in service, we have equal experience. That is the difference between Sivanandan case and this case. That letter single judge has clearly stated in paragraph 50. Now I'll come to that. So now, from the day advertisement was issued, the law started enforcing. Now on 8/2/2016, calling letter was issued to all of us with certain modification in the credit. Then just before one day of the written test, that is 12th July, one day before written test, they modified the criteria again without our knowledge. Notice was never, after speaking the Philippine report. Without notice, just President, according to them, President Rajbhavan, Lordship knows Rajbhavan is such a restricted area. Who comes and read the notice board in Rajbhavan? On 13 is the examination, 13 July. That day itself again, right after the written examination, after scrutinizing our results, again in the evening of written examination, once we were all out from examination hall, they said, the board said again, on the same day, 13 evening, had meeting, modified the criteria again.
What?
Modify the criteria.
In the advertisement, the sequence was 50 for written examination, 30 for interview, 10 for
work experience.
These 20 for work experience. Then in the call letter, what was done? 60.
Correct.
60 written.
60 for written.
30 for interview. 10 work experience.
10 work experience.
Yes.
Then on 12th, what had happened?
On 12th, he did.
25 order as 15 experiences.
Yes, ma'am. On 12th, they have, after scrutinizing, Lordship Land a single judge has given clarity. After scrutinizing all our performance documents, again they said and changed the criteria. Now 13, my lord. 13 was the examination date. 13/7 was the examination date. After conducting selection test, in the evening, board members said again, and they modified and changed the criteria again. Selection board decided to relax the minimum eligibility criteria work for the written examination from 50% to 45% again after scrutinizing the result of the written examination of the candidates. Horrible, my lord. After written examination, they said again meeting.
No, but this doesn't affect you, no?
Whether I'm talking about law, whether it affect or not change of the rules, I'm saying. I'm coming to that. Now, after that, on 14 July,
That is here like the problem. Minimum percentage.
14 July, oral was had. Now, Lordship will see. Just I have made a chart. How changes has affected the whole examination. First, the table below will show last page, man, last page. Last page, man. I make a tabulation, man. Last page. Man. The table below will show how the marks was allotted by the selection board by changing the rules of the game on 12/7/2016 and 13/7/2016. Table. Serial number 9, written examination is 60% of 200, oral into 25, academic and professional course 15 marks. Now, one is the appellant now, Lucy Cognac. That's one number 6 in repetition. Now, she secured in written examination, she secured 31.40%. In oral, she secured 17%. In professional efficiency, this is not practical, just considering that qualifying certificate added 12% out of 15, my lord. Then in my case, serial number 2 is me. Out of 100 written, I secure much higher than hard. In oral also, I secure much higher than 21. In professional academic certificate, I was given 5. Now, Lordship will see, had the rule not been changed, the academic and professional course percentage would remain 10 below the judgment.
Now, just a minute before that, you show me from this brief the decision taken on 14th of July for reducing the minimum, reducing the cutoff. Where is that decision?
That's from
Page 162, Lordship.
Page 162. This is
Reason is
this is on the day examination was held, 13 July 2016. Decisions taken during the meeting of the selection board. On scrutiny, the word scrutiny, on scrutiny of the result of the written test of the candidates, the board felt that only 3 candidates could secure
There is no surprise like that. Upsetting the entire process will be all legitimate expectation and she will not put the job to understand. Which means that 10 years of fast forward or maybe see it is where it is when probably. And there's special circumstances on the beautiful. That's sad.
My lord, coming by the second changes, that 12, may I draw lordship's attention, page 159. Second changes. First is that 12 July 2016, the decisions taken during the meeting of the selection board on scrutiny of the work experience, knowledge, and proficiency in computer, educational and professional qualifications of the candidates shortlisted for the written test. The board, after taking into account the work experience and special qualifications posed by the candidates, has observed that there is a need to review the marks kept for oral interview, and after detailed discussion, it was decided that marks in the oral interview may be reduced from 30 to 25, and the mark for the work experience, knowledge, and proficiency in computer, educational and professional qualification may be increased from 10 to 15. Lordship, what happened is this. In written, I say higher than hard. In oral, I say so this professional efficiency, this is not practical thing. Just seeing the certificate. They try their best to help. I'm sorry to say that. Decision was just to help a particular candidate by increasing from 10% to 15 for no practical class test. Just to see whether she's MA, BA. Both of us have computer knowledge, same profession. Except that she was MA. Both of us
Are you still interested?
Very much, man.
Why?
Because
10 years have passed by.
yes. So that, my lord, that is another aspect. I'm interested because look at that. Look at the job satisfaction by law. Look at this. Because lordship is lordship upheld. The decisions of the selection board. Lordship knows very well that answer.
Single judge's judgment, was it stayed?
Is
That's why I'm continuing service.
That's correct.
Because my when was first said that I lordship and single judge.
My lord, on that day, yes, when the matter was moved, the honorable judges of the division on that day felt that notices were issued to us, and knowing fully well I participated selection process on that. How can you turn around, come back and fight in the report? That was the understanding of the two judges when the appeal was moved. That's why that would stay. So therefore, now we have come to know from the judgment of these participants.
अब जजमेंट अभी लिखा है ये, यहाँ नहीं, इधर ही लिखा, आज लिखा है।
Let a single judge has. Let a single judge.
इसको टाइप करो, दूसरे को भेज दो। Yes.
So when the appeal was moved, the honorable judges of the division bench that time were not aware of the judgment passed by the Supreme Court that if the petitioner had no knowledge and participated, the selection test.
No,
So-
that's not the issue.
So therefore now that's what step was done then.
कुमारी कौन सा है? कुमारी मीता Sahai. This originates from Patna.
My lord, this is Ramjit Singh, Kardam and others.
No.
Versus Sanjeev Kumar and others. My lord, this is reported in 2020.
No. That is not an issue.
So therefore today, I'll just read out one paragraph.
We are not at all focusing on that argument that you cannot now question. Absolutely not.
Lordship, I'll just.
We are only, as both of you are arguing, we are only reappreciating in our minds what prejudice has been caused, number one, whether the law has been infringed, whether practical view has to be taken or not, and whether it is possible for the examination body, recruitment body to change the benchmarks at various levels, but only on informing. And whether the last of the changes by reducing the minimum eligibility, so far as marks is concerned, qualifying marks, from 50 to 45, whether it affects anybody adversely, number one.
As per
Quality is affected, what the single judge says. But only 3 candidates, therefore, it is the practice in all recruitment drives that the cutoff is lessened. It has always survived the scrutiny of the superior courts.
And today was for 50 above.
My lordship, I'll just read out one paragraph 50 of the letter single judge judgment. Why? Because my learned friend is relying on Tivananda's case. That at least this protection should be given apart from merit. Now I'll just read out what letter single
Like I said, he doesn't say apart from that. All right, yes.
May I read it?
Yes.
The submission of the letter senior counsel appearing for the respondent 6 made on the basis of the decisions in Sivanandan CT Supra in this is considered. After due consideration, this court finds no similarity to provide the same relief as in so-and-so CT Supra to the respondent number 6 in the event the responder 6 does not emerge as the candidate securing the higher marks between the two. From the advertisement dated 21/11/15, it is evident that the selection process was limited only to candidates who are already in service in the government with a scale pay. If during the pendency of the writ petition, the petitioner is rendering service in a hard post in the transport department, government of Nagaland, then the petitioner is also gaining experience like the number 6, who has gained experience in the post of secretary assistant, same her appointment was 3/8/2016. Thus, the case of the petitioner herein cannot be equated with the petitioners in Sivanandan's city Supra to reach the view that if the petitioner emerges as the selected candidate for appointment, the same will be contrary to public interest.
No, that's right. But then the court did take into account, the single judge did take into account. And therefore, instead of setting aside the entire process, he says that only from that stage, number one. Therefore, don't you think it is contradictory?
Yes.
So either if he was not satisfied, he should have set aside. The process would take another 5 days. Only five tribes have been called serving tribes.
6 tribes.
6 tribes. Serving people.
Yes, 7.
There would not be many people.
No.
So this could have been done. So part wise, segregating this part, that part, then accepting some change in the earlier part, not accepting change in the other part, not testing it on the anvil of Article 14, not testing it on the reasonableness, nexus ground. I mean, this either we set aside the entire thing and say that no, fresh procedures should be adopted. Midway, I don't think, and he took note of the fact. What Sivanandan says, he agrees to it. He says, first confirm. From I forgot your name, sir.
Mr. Ajoman.
Huh?
Ajo.
Mr. Zo. He says the judge, single judge says, first ask Mr. Zo whether he is interested. If he is interested and he gets better marks on recalibration, he must go. Mr. Takamasha must leave. But then if there is any other vacancy, she should be accommodated and the seniority will start running from the second date. So this is heavily loaded in your favor against him. All right. Yes.
Yes. Much of my
Lord's parents, since my learned friend has so raised about the marks allocation, which in qualifications I make the chart for my Lord's parents. Whether the special court has rightly awarded marks with respect for the vintage as well as the number 6. This is their qualification, as well as professional.
My only question is that should have been done at the time of advertisement. This is what that was.
All right. Somebody to write?
Just my personal stuff, especially the honorable High Court judgment with the appendix in the partition. Here, Lordship, Sivanandan was found in equity was exceeded by all the other.
That's what we said, no?
Yes.
That's what we just said.
Lordship, yes.
Why this Nagaland rules of business? Why is it here? Mr. Khan, take note. Please give your appearance slips. We have heard so and so. Both the appeals have been taken up together. Both the appeals have been heard together. We have heard so and so or so and so in appeal numbers. Put up for judgment tomorrow. For judgment tomorrow.
No problem.
To make the best use of the time here in Nagaland.
I appreciate the fact, one thing, that observing from the morning, you got to speak from the heart, not from the head. So very comfortable with us because we speak from the heart.
Yes.
What we think. So that
Yes.
we appreciate.
So we'll make the best use of time in Nagaland and not delay the delivery of judgment. Whichever side it turns, you have to accept it. All right. Any other matter? Thank you.